Because this week, Monday, we were. That's why I know.
What do you want?
The agencies are not petitioner retirement on the last day of this month. Your lordship fixed this matter as a specially fixed. But for last 2 weeks, when it was not reached. So,
But Mr. Department, we won't be, this bench won't be there from first because I have my circuiting job. It is better you mention.
your lordship will take up only on Thursday.
Yes.
Lordship,
You hand over this.
Lordship, may I be permitted to mention one matter has been allowed,
I can
mentioning was allowed by this honorable bench, my lord.
Yes.
My lord, kindly fix the matter under the heading to be mentioned.
Why?
My lord, what happened, my lord? In this matter, my lord, the appointment of assistant public prosecutor in trial court. The matter has,
Matter are you mentioning?
my lord, WPST.
Yes.
That has been allowed by this honorable bench. My lord, what happened, my lord? Why it under the heading of to be mentioned, my lord? My lord, what happened, my lord? In this matter, on a similar situation, the matter has been preferred before the Supreme Court under the heading SLP. That SLP has been dismissed. They have filed review application. That has been dismissed. Now, my lord, it is in within the domain of High Court. High Court will decide the issue, my lord. Already issue has been decided by the Supreme Court in the similar line, similar action, my lord. My lord, kindly fix
It will be mentioned. Why it has to be hard?
My lord, will take 5 to 10 minutes to dispose of. The issue has already been decided by the Supreme Court, my lord.
You are for the petitioner?
I am for the appellant, my lord.
Who is your other side?
My lord, I have served the notice, my lord.
This way, it cannot be kept under to be mentioned. It is in
My
the
lord,
list.
fix any date, I'll give further notice, my lord. If your lordship fix any date, any time, my lord, and
Come back next week, we shall consider.
to be mentioned, any
It
time.
cannot be to be mentioned, sir, because it is a contested matter. We do not know what is the stand. Yes, next.
Lordship, may I be permitted to mention one application for rest?
Mention on Monday. Yes.
In this matter, I am appearing on behalf of the appellant. The appellant is not willing to proceed this matter.
How many petitioners are there?
Only one.
You are for Shahidul Islam.
No,
You are
Syed
the
Nazmul
appellant.
Appellant, Syed Nazmul Hussain. I filed on behalf of that.
Bijon Mukhobal. You have given notice to your other side.
No, no.
It was headmaster approval. You are the advocate on record.
Yes, I am at vote on record.
The appellant here is challenging.
You are appearing for
My learned friend.
appellant is challenging.
Appellant challenging the order whereby the district inspector of school cancel the appointment of the private respondent who is the writ petitioner before lordship in compliance of the court's order.
But that was the subject matter challenge. In the meantime, Lord, retired on 29th, the appellant. That's why he did not want to proceed with the appeal, Lord, at this stage. Lord, Lordship, since he is retired, Lord, on 29th February 2024.
But he was not the writ petitioner.
Appellant.
Your
He is
client
appellant, yes. yes.
Appellant.
was not the writ petitioner.
No.
Appellant.
Appellant. I'm the appellant.
Challenge the order because the court said that cancellation was wrong.
Yeah, cancellation was wrong.
Now
And
that
my
is
position was second, but if he was cancelled, then my position is.
such learned advocate request for the appellant submits, upon instruction, that the appellant does not want to proceed with the present appeal any further. In view thereof, the appeal and the connected application, if any, are dismissed for non-prosecution. In view thereof, I want to proceed with the topic. Let the written instruction, as produced, be kept on record. তারপরে in view thereof.
I am for the petitioner. But that matter was the transfer.
What happened?
Petitioner attended on call. He sent the message and he attended. She attended the hearing. Hearing was made on 9th March. Already, now what happened? They want.
Joined.
Yeah, I have joined personal losses order. Kindly, your losses order dated 24th January 2024.
Then what happened? Order
But-
passed?
Yes, no order passed. Your lordship, kindly see your lordship's order dated 24th January 2024. On instruction, Mr. Mukherjee submitted that her period of absence to be regularized and her salary to be disbursed. Nothing has been done. She attended the hearing. Now they wanted to treat the absent period as unauthorized absent. But your lordship knows that I have challenged the order which was inoperative because order was passed for transferring the petitioner to that Kashipur PS, which was no existence on the date of.
Are you getting your current salaries?
No, nothing has been given. Nothing, not a farthing has been given.
When have you joined?
29th January 2024, personal lordship's direction. I have joined the Kultuli police station. Thereafter, personal lordship direction, I have filed application for regularization and also for transfer.
You joined on what date?
29th January 2024.
Now you have been paid the salary there?
No, not a single.
When were you hired?
On 9th March 2000. On 9th March.
They have passed any order?
I do not know. This is my learned friend
My
can
learned
say.
friend should have taken proper instructions. My learned friend paid for time, 3 days time to production of the medical certificate.
That is another issue. I have submitted that. I have sent that.
He should
All
have
the
been
medical
disclosed before the
certificate.
honorable court.
But now they want to treat
No,
it.
no, whether you should
Yes.
disclose the
Yes.
Fact.
I have sent, madam.
But your client has done before the SP.
No, I have sent, madam. I have sent my medical bill, medical certificate, everything I have sent.
No, you have paid for 3 days time.
Yeah, by this time I have sent.
Then why you are not saying that? Mr. Mukherjee is telling you to tell the correct facts to the court.
But on that day,
Mr. Roy,
No.
what you are wanting, we do not
no.
understand.
On that day, madam, the authority wanted to submit the why the absence was caused and wanted to produce the medical certificate.
Didn't say that at the beginning.
Ma-
You didn't say that at the beginning.
No,
You said I was hard, no order passed.
now, madam, I have sent the medical bill, medical certificate along with this. Now, madam, they wanted to, madam, kindly hear me. They wanted to regularize this, treating me.
Send. Mr. Rai, we don't understand.
Madam.
Before you file the medical certificate, you have already understood that they will treat that as unauthorized.
No, I have submitted. I have sent it. I have sent it on
When have you sent it?
on 10th. On 10th, I have sent it by speed post. On 10th, I have
Why
sent
did
it.
you appear before the officer with all the records?
I,
Do not understand things or what?
what happened? They wanted to submit. Now I will.
Give any explanation. You made a representation. You are saying that you were sick during that period. You will not produce the medical certificate.
No, I did not say, madam, that I was sick because The order itself was irregular order. The order was inoperative. That's why your lordship directed to find out any other place where the petitioner can join. Pursuant to a lordship direction,
Mr.
Ye-
Mukherjee, have you received the copy?
Uh,
Have you received the medical documents now?
yes, yes, this,
No, we are,
yes.
incomplete certificate has been submitted.
Incomplete.
Incomplete.
What incomplete?
But legal certificate, if somebody is absent on medical ground, there
Hmm.
must be medical certificate that because of these reasons he was sick or under by treatment. But that did not, that's why he prayed for another 3 days time,
Well,
So the last heard on when?
on 9th of March.
9th of March.
March.
Thereafter, he sent the documents when?
He prayed for, this document has been produced, hard copy. That has not been submitted,
Till date, he has not.
has not submitted.
yes, I have sent it by registered with AD. By speed post on 10th, immediately thereafter. 9th I was called, 10th I have sent.
When did you appear before this?
9th March and 10th March I have sent. I prayed,
March, if you don't give the certificates, what decision he will take?
my can see, they wanted to regularize.
Steps for
Among-
the regularization
but-
of his
No,
absence.
this is not a medical gown. Their leave was not medical gown.
It will be month of, on completion of March, this,
But,
after 20th March,
but kindly come to your lordship's order.
1st of April.
But kindly come to your lordship's order dated 24th January. Whatever this leave,
Wanting an order from us that we should direct the SP to regularize the period suo moto and disperse everything to you. That is the relief you are praying.
No.
Are you praying for that relief or not?
I am praying because
Operating করছে। Your client does not appear to be.
she is cooperating. Kindly may I make submission to also consideration.
No, why you have not
Yes.
set the correct figure?
This is they are one.
Just by mentioning the date when you are posted, initially you are posted where?
Kashipur police station, Kashipur.
Kashipur.
Yes.
Kashipur. When you are transferred from Kashipur?
On that is 18th October 2023.
23. Kashipur to?
No, Baripur to Kashipur.
So you are originally posted in Paripur place,
Baripur woman cell.
women's cell. As ASI of police.
Mar.
Then from Paripur to you are transferred to
Kashipur police station.
Kashipur police.
Mar.
Achha. Your contention is that there is no
Because there is no at the time the notification has been issued, there is no police station named Kashipur police station. It has been marked with the Bangur division, my lord,
PS
under Calcutta police.
Kashipur. Then you transfer to Canning.
Subsequent. Thereafter, my lord, I made representation on 28th October for transfer me another place. On 28th, my lord. Now they did not transfer. Then I moved before the London Tribunal seeking for transfer me any other place. They did not. Then when that was rejected, then I came before lordship. Now, my lord, your lordship then asked my learned friend to transfer any other place where the vacancy is there. Then they issued the order of transfer to Kuntuli police station, and your lordship directed me to join on Kuntuli on 29th. I have joined on 29th. Now, the period of lapse is not because of me, my lord, not a medical ground.
Yes, when?
On 29th January 2024, I joined pursuant to lordship direction.
Then it is joined now on
29th January 2024. And on instruction, my lord, my learned friends placed before lordship that this period would be regularized and salary to be paid, because this is not my fault. Because they issued the order.
They passed any order.
No, my lord.
How do you know that they will be doing this thing?
No, they wanted medical certificate. I have placed the medical certificate according to their saying. Now, this period, they wanted to regularize on the basis of medical.
Want to submit certificates, any further certificates?
No, my lord, I have sent it. I have sent it. উফ, খুব করুন। কথা বলছে তো কি হবে?
গন্ডগোল করছে।
ছেড়ে দিব সময় মতো তোমাকে contact করবো। বলছি, medical
The issue. If you become the leave sanctioning authority, you have to decide what kind of leave will be sanctioned.
But this is
Medical leave to grant the leave, medical leave. He wants one medical certificate. Or otherwise, you have to give any extraordinary leave, special leave, anything like that.
your
What do they
contention
handle
is
it?
your contention is that that period cannot be automatically, it has to be regularized without expending the medical leave which is lying in your credit.
Yes.
That's your contention.
my lord.
So first let them pass an order that what they are doing,
My lord.
they are regularizing with medical leave or with any other
Well-
leave or in any other manner.
My lord, I bow to
So if that order comes, if it is said that regularized by grant of leave, at least you will start getting your salary.
my lord, as your lordship.
And if it is illegally being regularized by expending the medical leave,
My lord.
that will create a fresh cause of action for you. First, you have to survive. Otherwise, how will you survive?
I bow to lordship. My lord, this is a fact I have expressed before.
No, you are not properly advising your client.
But
You
date
are
was
not
I have,
proper. You see that since the High Court has interfered, High Court wants to solve the problem. And we took the confidence of Mr. Mukherjee. We requested him that you see that this is done.
my lord,
Unless you get the salary, how will you survive?
my lord, my lord, my lord. I bow to lordship.
Then when are you going to submit? Now the election has come.
I've
Now
given.
how many times why didn't you appear before him with appropriate? You told the client that don't produce any document.
No, no, no. My lord,
Mr. Roy,
But-
this conduct is not proper.
my lord, I have sent it because
Why will you send it? It is your
because my
headache.
lord, I went
Why
there.
will you send it?
May I
You
say?
will not carry the medical certificates when
no,
the
no,
person is
No,
called.
because Madam Akasi, I went from Kaltuli police station. I went from Kaltuli police station directly to the Suvarnapuri police
You
office.
want to submit any other medical?
No, 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 I have sent it. I have sent it, madam. I have sent it.
Mukherjee, you ask your SP to consider whatever material
Yes.
is on record and to pass an order and regularize that period. If he thinks that it has to be regularized by medical leave.
But according to my instructions, sir, he would get salary in the month of first week because February salary he could not. 9th March he appeared. Then subsequently he had not produced the order, hard copy. Then subsequently by discharge post we have got it. Subsequently, then what we are processing, but it would be salary would be released in the first week of April because March salary would be after 31st of March because 31st March financial year ending most probably 1st April or 2nd April they will be credited to his account and the leave will be application will be considered according to law. What about the permissible earned leave or
No, his salary would not be paid unless you pass that order.
no, will be credited to his account from 1st April or 2nd April.
So we can record that, Mr.
Yes.
Mukherjee.
Just give me one second. Period of absence did not have been regularized, but salary of February has been released to the treasury.
From April and onwards, you will get current salary.
Current salary. And February salary will be sent to treasury.
You know? দাঁড়ান তো একটুখানি কথা বলবেন না।
Then when he will pass the order, Mr. Mukherjee?
Your lordship can dispose of the entire matter. We are taking steps to regularize his service, unauthorized period, whatever may be, leave, medical leave or whatever the leave is, or according to the rules, that will adjust his salary in for the month of February released it will be, will go, already been released to the treasury officer, he will get within a 2-3 days.
No, this you are making on oral submission, Mr. Mukherjee. You don't have any document, na? You will be in problem. Do you have the done that his salary of the month of February
Everybody has
been-
already been released, on to the treasury officer.
Then why she is not getting it?
Or it will take some time because of this election notifications, some official transactions.
Pursuant to the earlier order passed by this court, the petitioner, Mr. Roy Learned Advocate appearing for the,
Join.
Mr. Roy Learned Advocate appearing for the petitioner submits that pursuant to the earlier order passed by this court on 5th of March 2024, the appellant duly appeared before the superintendent of
Deputy Superintendent, Deputy Superintendent of Police, Deputy Superintendent.
before the deputy superintendent of police on, when did you give it?
On 9th March.
9th
March.
On 9th March.
It- মায়নাটা না পেলে তো হবে না, পোস্টিং বলবো না।
Stop. She has also, thereafter, she has also sent the medical medical
Made an
documents.
application for regularization is Bureau of Service.
কেন অ্যাপ্লিকেশন তো করাই হয়েছে, সেই জন্যই না মিট করতে বলেছি, সেটা তো বলেছে
And she had sent that.
কি লিখলে when did you send the medical
On
document?
10th March,
He appeared on
She
9th.
has
10th March.
send the relevant medical documents to the deputy superintendent of police on 10th of March. But no final decision has yet been communicated to the petitioner.
But to the Superintendent of Police, I've sent it in the,
The superintendent of police give that. Let the documents as produced, be kept on record. Mr. Mukherjee Learned AGP appearing for the state submits that the medical documents have already been received by the deputy superintendent of police and necessary orders will be passed by the said authority. Answering our query, he further submits that the petitioner's salary for the month of February 2024 has already been released and sent to the treasury.
Treasury officer.
Has all the salary submits that the documents towards salary. Salary for the month of February 24 had been forwarded to the concerned treasury,
It will be kept in our account.
and the same would be credited in the petitioner's account in due course. Stop.
transfer.
As no final decision as regards regularization of the period of absence has not yet been taken, the matter stands adjourned for 2 weeks. Please the matter for further consideration under the same heading in the daily supplementary list of this court on 10th April. Mr. Mukherjee is directed to place the order of the, who will pass it? Deputy Superintendent.
Deputy Superintendent of Police.
Mr. Mukherjee is directed to place before this court the order to be passed, placed before this court, order. Is this matter on the Mr. Mukherjee, stop. On the returnable date, Mr. Mukherjee shall place the order which shall be passed by the competent authority considering the petitioner's representation towards regularization of the period of absence.
May I make one submission? The petitioner made a representation for transferring her on 5th January to February 2024. But in the meantime, 21st February, they have transferred number of persons who are suffering from mother suffering from cancer or father suffering from cancer. This is this. But petitioner though,
Come back on that day. Let us see what.
During elections, now we have no power.
Let us see. Mr.
Except
Mukherjee,
Election
also
Commission of
not-
India.
Let us see.
madam.
লিখে দাও তাহলে সাহেব। না না লিখে দাও লিখে দাও না।
On the part of the and also the
ওটা ভুলে ওটা রেগুলারাইজড হবে
Not today. Mark.
Item number 3, I'm
Ballot.
Mr. Devendra and Maro.
In this matter, ballot, I'm for the petitioner, and your lordship last order is quite candid in order to understand the entire facts, ballot. It's only with regard to the father has relinquished his right to appoint being a land loser. The name of the son has already been substituted by the authority. They have issued the call letter, but their impediment is that son has not applied. That is their contention. The son has not applied.
Father applied.
My contention is that since the son has already applied, therefore the call letter has been issued in his favor. Despite that, ballot, there is an impediment with regard to the instruction, and they are taking this ballot.
When have you called for the test?
Test, ballot, the test was called for.
No, what had been the development? You are saying we have recorded that
Yes.
his son.
Yes, everything
What
is.
is your instruction?
My lord, Mr. Rai, my lord, he is engaged in court number 654.
So
my lord.
every day he's
My lord,
engaged in.
he is just coming,
Huh?
my lord. I'm
Whenever
praying for
this matter
only
takes
5
up.
minutes possible, my lord.
Mallet, may I pray, Mallet? Two matters having in a central administrative tribunal, Mallet, at item number 7 and 10, Mallet. May I come back from CAT, Mallet, and make it 2 p.m. if lordship pleases to do so?
Then not today.
Okay, Mallet, 5
5
minutes.
minutes possible.
I'll take the passover there, Mallet. Because each time, Mallet, the client is being harassed, Mallet. ठीक है, हाँ, wait.
7 and 8, what you are mentioning?
No. In a central administrative tribunal, I am having matter, Mallet. So therefore, I thought I will do it and I'll come back.
Then, my lord,
But
Passover.
he's insisting to pass over. Let it be Passover, Mallet. I'm waiting for it.
That is also before this court. Those two matters are.
No.
So what are you praying?
My prayer is that, Mallet, since my learned friend is insisting for Passover, let it be passed over, Mallet. I'm waiting for the learned senior to come. I will do the matter itself, Mallet.
Yes, next.
Yes.
Lord, I appear for the alleged contempt.
My lord, I am for the petition led by Mr. Lallatan Munni.
That postal matter where the gap is to be considered and pension. Lord, on 14th, we have paid the entire amount. Lord, we have
Yes.
paid the entire amount. This is the breakup. An application has been filed with your lordship's leave. That is also appearing before your lordship. Now, if your lordship kindly come to
The application.
Can 1 of 2024. There is a statement in the application. Your lordship will kindly come to page 21-23. Total 22,74,230 have been paid. There is no outstanding pending. Everything has been paid. And the breakup which you have given handed over, kindly look into this.
Have you-
Yes, ma'am.
What was our parent order?
And he has withdrawn, he has withdrawn from this payment rupees 20,000 and 4,000. 4 lakhs and 20,000 on 18th March and 16th March respectively.
Upon condoning the shortfall of service, you have granted the.
Yes,
continuous-
everything has been paid. And your lordship judgment and direction has been fully complied with. If your lordship kindly come to the breakup I have handed over, there the details have been given.
You have.
And current
Yes,
pension.
Yes, ma'am.
And the current pension has also been
Also, the Mr. Chakraborty, learned ASC, appearing for the alleged contempt, not one contempt,
3 contempt.
appearing for the alleged contemptors, submits that the order passed by this court on 12th September 2023 in WPCT 57 of 2023 has already been complied with, and upon condoning the shortfall of service period of the petitioner up to the extent of minimum qualifying service for the purpose of granting pension, and has already been complied with, and upon condoning the shortfall of service period of the petitioner, he has been disbursed all the consequential benefits,
including the current pension.
including the current pension. He further submits that there was no deliberate, submits that the delay which has occurred towards compliance of this court's order is not intentional. The fact that the consequential benefits have been disbursed in favor of the petitioner, and that the current pension has also been, and that the current pension is also being paid, has not been disputed by Mr. Sadhu learned advocate appearing for the petitioner. In view thereof, we are not inclined to proceed with the contempt application any further, and the same is accordingly, and the same is, what is this application?
The disposal of credit.
Accordingly, proceed with the contempt application in the further stop. Accordingly, the contempt application and the connected application, and accordingly, the contempt application and the application filed in connection with the same are disposed of. There shall
And my lord, the personal appearance virtually for tomorrow is also
disposed of, Mr. Chakraborty.
My lord,
Your application has been disposed of.
very well. And my lord, the written instruction may be taken on record about the breakup.
আচ্ছা, ওই মিস্টার চক্রবর্তী ফার্স্ট প্যারাগ্রাফে যেটা বলেছেন, let the documents, as submitted, be kept on record. এটা আরেকটা, the appearance of the alleged contemptor through online mode.
Tomorrow. For tomorrow.
as directed in the order dated 11th March 2024 is also dispensed.
Yes.
Yes.
My lord, would your lordship please to take the pass over?
Lord, in fact, Lord, in terms of your lordship's last order, Lord, I was supposed to take further instruction in the matter. Lord, I have talked to the concerned officer. Lord, thing is this, Lord, the father did not apply on the category of land loser, and he has Lord, he is now overaged for service. The son is also an applicant. Now, Lord, the thing is this, Lord, son also did not apply. There, but the admit card which was issued in favor of the son, that is annexed to the supplementary affidavit, that was out of since litigation was on, therefore he was asked to appear for verification. The,
Want Mr. Doyle.
I simply suggest, subject to your lordship's kind consideration, let the son's application be considered. Whatever required policies are there, that should be complied with. Let the application of son be considered, taken into account for land losers category.
I have already called him for.
But there is a technical.
Have you?
Yes,
called
yes,
him?
yes, yes, yes.
When you have called him? For what?
What to be?
Show us the document. you have been called.
Page 140 of my learned friend's main application, page 40. Well, 1st March 2022, date of document verification. 140, page 140.
Yes.
Right? Yes.
You called him for document verification
Yes.
on
1st March 2022.
now, Mr. Roy, where he will now, what is the requirement of filing a fresh representation? It is a fact we have recorded in our-
I don't say, Lord.
Have you
He
seen our last order, Mr. Roy?
yes.
We have indicated that
Yes.
he says that the son's appointment will be considered.
Right. Lord, if your lordship directs, Lord, I'm just suggesting, Lord, subject to your lordship's kind consideration. Lord, the technical hurdles which are appearing before the concerned authority, that would be given a go by. Your lordship directs for consideration of the son's case in accordance with law. That would suffice.
But, yes, we will detect that, but for that, if he has to submit now, if your officer says, no, bring that document, this document.
No,
if
but
further queries are made.
But his application would be considered in accordance with law. The father's application won't be considered because he is.
We have recorded that.
Yes, Lord.
We
Yes,
have recorded that.
yes,
So both of them apply.
yes,
Application is with you.
No.
yes.
Sirajul
Son's application must be around with
Hmm.
testimonials.
The son's application is page 144, your lordship. Even they can treat this application as a de novo process if they are not having that.
Yes, but since both the applicants were there, both the cases could not be considered. Therefore, a technical issue arose, my lord.
So you consider and come and tell us, we will dispose of the matter. That is what we want, we were inclined to do. That is why we gave you time.
Lord, subject to Lord, kind consideration of your lordship, Lord. Your lordship disposes of the application, we shall consider the son's case. That's all. We shall consider the son's case. Right? বলে দে এসছে কেউ সবই আছে ওটা অ্যাপ্লিকেশনও আছে গেট ছেড়ে আসছে কি করে গেট ছেড়ে কি করে আসছে
Now, Mr. Bhushan, that was the order of the tribunal, that he should be considered.
No, my lord, the tribunal's order was that, well, it was simply disposal of the representation.
Yes.
I have not made any representation, but since the 4 or 5 application was heard together, passed a common order. So therefore, my merit was not depicted in the said order. My merit was that despite my application, there was no representation pending, but tribunal has directed a invoker's direction to consider the representation, my lord. And here, by the inherent defect in the tribunal application, my lord, when this part B came into existence, were not eligible due to not applied, that was there, my lord. But learned advocate who filed the application before the CAT below has not challenged that order, my lord. And it was just superficially the entire draft was done, and even the court has not undergone merit of the application. So therefore, my lord, my intention was that, my lord, there is no impediment with regard to the candidature is concerned, my lord. The validity and the legality is nowhere it has been challenged. Only the matter of application. If your lordship pleases to do so, let my application 144 be treated as an application here not having, and the entire procedure be dispensed with within the stipulated time frame, my lord.
Now you will be called for document verification. First date will be for document verification.
We have already appeared, my lord.
Uh-huh.
No, for the document verification,
Uh.
son Sohail Malik has already appeared. He has submitted his document, but thereafter, there would be the second stage, that is PET, which has not been commenced so far as the applicant is concerned, petition is concerned. Well, so if I have gone through the document verification, the second stage would be the PET, my lord, then after the medical, then the appointment letter. Only 2 stages are left, my lord.
Yes, now tribunal directed the representation to be considered in the light of ABC.
ABC, my lord.
Now your problem was that your representation was there on the record.
No, I have not given any representation to that effect, but the tribunal, for the sake of convenience, taken 5 or 6 land loser matter because a plethora of matters was pending before the tribunal. So therefore, they clubbed my application also with the same chain and passed an order with regard to consider the representation matter without going into the individual merit of the application.
Why have you come up before us?
I have come up before your lordship because that point of time, since the tribunal has passed an order whereby representation was not pending and they have directed to consider the representation being.
But why your representation was not pending? You made an application.
Representation, my lord, I have passed through the representation stage, because representation stages are for those applicants who have made their first application representation to consider me as a land loser candidate. These are the stages which I have crossed. I have come to the stage of the document verification. But this particular merit of my application has not been well canvassed before the tribunal, my lord, and they have put an identical order to consider the representation, my lord. Being agreed with that order, I came before your lordship in a writ petition by filing that I have already commenced the entire procedure so far the land loser is concerned. My father has already relinquished the right in a long back that has been admitted by the respondent, my lord, and the son who has having all the legitimate criteria to qualify the land loser criteria. That is my contention, my lord.
Achha, Mr. when the matter was last heard on 5th of March 2024, Mr. Bhushan Learned Advocate appearing for the petitioners submitted that in place and stead of Sirajul Mollik, his son being the petitioner number 1, applied for the appointment under the land user scheme. However, it was submitted, where is that? However, during pendency of the present application, during pendency of the present application, the respondents issued Stop. However, during pendency of present application, the petitioner number 2 was called for document verification. Stop. In the earlier order, we made it clear that in place and stead of Sirajul Mollik, his son being the petitioner number 1 should be called for document verification. And we accordingly directed the respondents, learned advocate appearing for the respondents to avail necessary instruction. Today, Mr. Roy Learned Advocate appearing for the respondent submits that in place and stead of Sirajul Mollik, the petitioner number 1 will be called for document verification. In view of such submissions, no further order is required to be passed in the present application, and the same is disposed of. It is made clear that after document verification, all necessary it is made clear after successful completion of document verification, all necessary follow-up steps shall be taken by the respondents as expeditiously as possible. In the light of the circular RBE 99/2010, along with the extant rules and policy in vogue, as well as various orders passed by the tribunal and also by this court in similar matters.
Deeply obliged. Grateful, Your Honor.
Lord,
What is that 99? RBE 99?
99 is the parent circular issued by the railway board with regard to how the process of the recruitment to take place for the land users permit.
The writ petition being such and such is accordingly disposed of. Yes.
Lord, after document verification, follow-up steps should be taken expeditiously, provided the documents are found to be all right, my Lord.
We have said that.
Yes, my Lord.
Upon successful document verification.
I'm grateful. I'm extremely grateful. Yes.
Yes.
Deeply obliged.
Five.
Lordship, in this matter, for this response that I'm paying for this, the adjournment for this 1 week, Lordship.
আগে শুধু অর্ডারটা দেখ 2 weeks.
Lordship.
Yes, my lord, I am for the appellant. কোথায় গেল? Respondent কোথায় গেল?
You are for the appellant.
Yes,
Is your other side, Mr. Hotel?
Mr. Vijay Raya for the respondent. I appeared to the Mr. Vijay Raya will have to appear.
Ujjwal Raya.
Basically, he was not passed over.
Not this week, yes.
My lord, next week I will not be available. Out of
Your
Calcutta.
Lordship, subject to approval, my lord, man,
What is the matter, Mr. Hotel?
Matter is, my lord, the imposition of punishment of recovery of 8 lakhs rupees. According to the tribunal, it is an excess punishment. Although the allegation, imputation of misconduct containing the allegation of charge,
Paying for accommodation on behalf of the respondent, Your Lordship.
Then we will keep it on 2nd of April.
my lord,
As my lord pleases.
there's an urgency because my lord, the man is already retired for
At 2nd of April, we will take. You are not ready to do the matter today. On your prayer, we are making it 2nd. Yes, 2nd April.
Obliged.
Lordships, I beg to appear for the petitioner in this matter.
Have you served?
I have served the copy.
Yes, tell us what is the matter.
My lord, this is a matter arising out of land usures issue.
Item
The
7.
Item number 7. My lord, the matter is arising out of land usures issue where the petitioner was called to appear for the physical efficiency test, and the result of the physical efficiency test disclosed the candidature of the petitioner has got rejected, stating not qualified, and thereafter the other applicants, those who have appeared with the petitioner, they have been provided recruitment in the month of December. But the petitioner's application has not been considered. Though, my lord, there was a direction of the tribunal that the selection process should be completed following the directions of the Honorable High Court in CPAN 277 of 2022, that the petitioners will appear in physical efficiency test without prejudice to the rights, because the physical efficiency test was
What is the wrong with this order?
the wrong with this order is, my lord, the impugned order is, we have filed an original
Why
application.
you are saying we? There was only Sangita Mukherjee.
There is only one petitioner.
Your original application was disposed of with a direction upon the authorities to consider.
My lord, actually the matter is, we have filed a representation. We have filed a representation with the respondents that the result has not considered the judgments of the Honorable High Court, Calcutta.
Have they passed any order?
They have
After
passed
the-
previously, they have passed an order.
After this order, on
Yes.
your representation, did
They have not passed any order.
Then why you are before us? What is the wrong with this order?
My lord, the wrong with this order is that the tribunal has not disposed of the order on merit. I have,
What is the wrong with this order that you have preferred the writ petition?
my
Come
lord,
to page number, internal page number 3, paragraph 4.
my lord, the paragraph 4 states that since the applicant herein has submitted his representation for redressal of his grievance before the competent authority on 20th of November 2023, and as such, there is no decision on the same till date, we deem it fit to dispose of this OA at the admission stage with the expectation that the competent authority will consider and decide the pending representation of the applicant expeditiously and intimate the decision to the applicant forthwith. Now, my lord, if the tribunal has considered the application on merit, then they should have passed an appropriate order that the petitioner should have been called for the medical test, and within some time, the matter of giving compassionate appointment should have been completed. But the tribunal has not entered it on the merit.
Tribunal cannot decide. Tribunal has relegated the matter for consideration.
But my prayer before the tribunal, as my lord
It
can,
was disposed of at the admission stage, asking the authorities to consider.
my lord,
Now, any final order was passed thereafter.
my lord, final order they have not passed, and they have rejected my candidature. That's why I have appeared before your lordship.
Where is that order?
Representation. My representation, my lord, is at page number. My representation is at page
Is
number
your
320.
service upon all the respondents? Have you served this copy?
Yes, my lord.
Where is your service?
My lord, I have made the affidavit of service ready, but the entry punching is not yet done since I was ill and I could not come in the last week. My lord, my prayer was that the matter should have been disposed of in the.
Come next week, complete your service. Bring the affidavit of service. Yes, not this week.
My lord, item number 8 is also a similar matter. And in
7 and 8. Complete service and come.
My lord, may I have your lordship's kind indulgence, my lord? In item number 1, we have not been noticed. They have mentioned, shall I give my name, my lord? For
No,
the
we
state.
didn't pass any order. We simply kept it after 2 weeks. No order was passed in one. Item number
1.
non-prosecution.
Yes, my lord. They have not served any notice upon us. The
You are for whom?
state of West Bengal, led by Mr. Chakraborty.
ওই একটা যে নিয়ে গেছে ওকে বল। জয়ন্তকে বলে। Yes, next. 7, 8, 9 same.
my lord, item number 9 is bit different.
Have you completed service?
My lord, the affidavit of service is entry punching is pending, but the
Come next week. Yes.
Well, at 10, I appeared on behalf of the petitioner. That is that matter where my lord,
I am for the private respondent.
the single bench can take up the matter in spite of direction of the court. The tribunal is not taking up the matter. Your lordship directed to take a specific instruction.
Who is your other side, Mr. Boy?
My lord, somebody was appearing on behalf of the state. He assured the court that he will take instruction for the learned government PD, whether it can be disposed of.
Come on second. Yes.
Well, it will.
Second day.
Second day.
You give on.
Or should I come at 2 after giving notice? If
2, we have a fixed matter, another bench will be sitting. Yes, next 11.
Second day.
11, who is appearing? Your
Lordship, Mr. Tapan Kumar Mukherjee appearing on behalf of state, engaged at courtroom number 22.
2 weeks. Yes. Same.
For not this week, my lord.
Same.
Your Lordship, I appear on behalf of the state.
Same.
I am for the petitioner, item number 15.
You have complete service.
Service completed, my lord. State and school authority is duly received on yesterday, my lord. But
WPST.
yes.
Your grievances against the school.
Against, my lord, I have made a representation before the school education department, which is lying before the authority, and learned tribunal refused to my application, even directing the authority to consider my application. But I am a school teacher of a government school teacher appointed to the Public Service Commission. And my lord, I now posted in the South 24 Pargana, seeking transfer in my home district Murshidabad, various ground. My lord, there is no scheme at all. My lord, I made a representation that my representation should be considered sympathetically, repeated one after another representation. Authorities not touched my representation. I filed a way application only considering the representation. but that application has been turned down on.
No, did they take any decision rejecting?
No, not decision. I'm only praying let the application be considered, nothing more.
Under which provision it will be considered?
My lord, there is no, I candid to your lordship, there is no scheme at all, transfer.
How can we deduct?
My lord, sympathetically, since my application is made, at least subject to my consideration and satisfaction, they should.
Your application.
Yes. My lord, my representation, my lord, page 25, 24 and onwards, my lord, 3 representation I have made.
Where is who is for the state?
State, my lord, I have served. My lord, this is first time appearing.
Unless there is.
Lordship, let it be not today.
Not today, they'll make it not this week.
Not this week.
Yes, next.
For the state respondent, Recruitment
2 weeks. Okay.
17 minute time for the petition.
After your service is complete.
Complete. My lord, my opposite party started to miscase. One miscase in the year of 2021 and another in 2022.
Where is your service? Affidavit of service you have checked up?
Yes.
Checked up.
In page number 36.
Yeah, just down. What is the wrong with this?
My lord, in page number 36, first miscase started in the year 2021. Same Khotian number, same DAG number, same cause of action. It has been already here, and order is pending there. In the same cause of action, opposite party filed another miscase, page number 38. That is in the year 2022. And learned tribunal has
Getting to the same plot of land.
same plot.
So you go and tell that before the officer. That is what the tribunal has said. Consider the representation.
My lord, I have already uttered same thing in the before the tribunal. Tribunal, as the opposite party suppressed the matter that time, so tribunal passed this order.
No, thereafter, after this notice at page 38 was issued, did you appear before the officer on 7th of April?
Yes.
Oh, date is on 22. You appeared.
Yes.
Then no decision has been
No
taken.
decision, because already 21 is pending there. Miscase number 1.
In respect of the same land, you have applied for recording and he has also applied for recording.
No.
Oh, the opposite party applied 2 times.
2 times.
First was page.
Page number 36.
That is, what is your opposite party? Alkesh.
Alkas.
Alkash wanted what? For recording of his name.
Recording his name.
So that was not disposed of.
That destroyed.
And he again filed another.
Original 35 of 2022 may be disposed of by the authority.
Page 36 is in respect of
35 of page 38.
38 is the second one.
That is miscase number 35 of 2022.
Earlier was?
Earlier was miscase number 186 of 2021.
সেটা কোথায়? সেটা তো অর্ডার শিটের কোথাও নেই।
Learned tribe, as opposite party suppressed the fact, so learned tribunal has not considered the matter. So for same cause of action, two applications are there.
Then, my lord, discard the next proceedings. Arrow to proceed and dispose of the 186 of 2021.
Yes.
If I take it, my lord, I haven't taken the instruction. My lord, whether it was renumbered or what is the reason, for that I need to take the instruction. আরে বাবা renumbered হয়েছে কিনা সেটা আমি জানবো কোথা দিয়ে?
Already first case also hearing has been completed and record has been corrected accordingly, but he is not satisfied. But
Case means 186 or 21 was disposed of.
not disposed of, my lord. It record was corrected for his favor. Hearing completed and we have submitted entire documents. He has also submitted entire documents. After that, he again filed separate miscase in the year 2022. So one miscase is pending there for final disposal. Again, opposite party.
May I come back with the instruction? Well, it happens on several occasions when I have seen that if misproceeding has started and they ultimately that particular BLLRO gets transferred, new BLLRO has come in the office, he does not find the records and then he starts with a new miscase. Let me find out what is the actual reasoning behind this.
Milord, in this my read application, my prayer was to set aside the order of learned tribunal, which has been passed with reference to miscase number in the year 2022. So learned tribunal order need to set aside, my lord.
বাবা সেটা না জানলে আমি কি বলবো?
Private respondent have been served one or two. Private respondent, how many private respondents?
Private respondent,
Only one private respondent.
That's why the service has been effected.
My lord, sir.
They have received.
Yes, that yellow slip is.
কোন district এটা?
পূর্ব মেদিনীপুর।
Let me find out.
Not that whether any decision has been taken on the basis of this.
My problem is, my lord, I am overseas worker. I am not staying here. But my wife is several times facing same problem with the BLRO.
Ashok, affidavit service filed by the petitioner.
হয়তো অর্ডারও হয়ে গেছে 186 এরকম হতে পারে। দাগ সেম বাবা কি হয় আমি সেটা বললাম।
And on being so approached initiated the proceedings being case number 186 initiated a proceeding case number 183 of 2021 and hearing of that case was concluded, but the same has not been disposed of. In the meantime, the private respondent again made an application and by making an application renew his prayer, and on the basis of such subsequent application another miscase being 35 2022 was initiated. And since the same was not disposed of, the private respondent approached the learned tribunal with this original application, and the learned tribunal has directed the concerned bearer to dispose of the miscase initiated subsequently. He submits that order passed by the learned tribunal be set aside. Mr. Learned advocate for the state sought paid for a short accommodation to have a necessary instruction.
Money.
Submission made on behalf of the respective parties and refusal of the proceedings and documents. Made out a good argument case and sequently operation of the order implementation the state
মাঝখানে
in the end of April or until further. Even which over is with this matter or further consideration. At the same meeting. 16th April. 16th April. The order includes state. Operation of the order.
and manner the proceedings
Will take instruction.
Mal.
The proceedings is subsequently initiated.
Yes,
The
if
same
at all, man, if it is not renumbered, man, regarding that, man, I'll have to come up.
Despite of service, no one appears on behalf of the private respondent number 4. Since no one appears on behalf of the respondent number 4, the petitioner is directed to immediately communicate this order to the said respondent and file an affidavit of service on the return.
communicate this order to the private respondent.
Grateful, Milord, kindly, third week of April.
23rd April করে দাও।
Grateful, Milord.
Dada.
Yes, next.
Recorded আছে.
18 my lord, in this matter, my lord, I am appealing for the petitioner. This is relating to not.
Lordship, I beg to appear with the respondent. My lord, I'm led by Mr. Galib. Mr. Galib is out of station, Lordship. So, Lordship, if your Lordship kindly take over him.
You do it. What is your injunction refused? What happened, my lord? This is because I have annexed the copy of the notice in respect of which the challenge has been made before the tribunal. May I hand over a copy of the, to some extent, legible copy of the notice? Because
You are appearing for all the.
yes, all the state respondents.
Oh.
The petition before Lordship proceedings was initiated under.
Just. Land reforms এর বইটা দাও।
If your Lordship may kindly enough to turn to page 88, the notice. This is a legible copy, my lord, because this notice is not quite legible. একটু জজ সাহেবকে দেবেন এইটার দিকে জজ সাহেবকে দেবেন।
So, Mr. Roy, you appeared before the officer, 12th of December.
Yes.
Now, how you
It is adjourned. Now this notice, my lord, issued is without jurisdiction.
you appeared before.
Yes, I have said that we have challenged the system before the tribunal. This notice is without jurisdiction.
Appearance was subsequent to tribunal application.
No, before that.
Before,
Before that, the notice was issued, we appeared and wait for an adjournment because this,
instead of waiting, my lord,
whether this notice is permissible under the law.
Take the jurisdictional point.
Choose it is, my lord, on the face of this, say, my lord, if I satisfy your lordship, the notice is without jurisdiction, then I am entitled an order of injunction or not.
Yes, tell us why. the-
Yes, my lord. Can you consider the notice itself? My lord, I have handed over a legible copy of the notice, my lord. It is quite illegible on page 88.
It is recorded as heart.
Heart. In the RS record of right, it is recorded as a heart. Therefore, this property cannot be retained under the Estate Acquisition Act and it should be vested. These are sum and substance. Not can you consider whether what does section 5(1) say? Not can you
Actual section 5 or 1A2.
A2. That is the effect of publication of the notification. Effect of publication of the notification. The notification is now consider section 6. Subject to this property has been retained is retained portion of the land of the petitioner.
Estate Acquisition Act.
Oh,
Yes, 5A. Now, my lord, your lordship can on section 5 once, my lord, for my satisfaction, my lord.
go on section 1, section 5.
Section 5 cannot stand independent to section 6. Section 5A, my lord, can you consider what section 5A? It is the right coupled with the estate which has been vested. If the right of the estate can be vested, it is the right. Shariati interest is the right which is there along with the estate. That is why it says that 5(1)A is all a Shariati interest. That is fisheries, hard, bazaar, and etc. If the estate of the intermediary is vested, then also the right coupled with this estate will be vested.
Right, coupled with the
Estate
Ah.
will be vested. If the estate cannot be vested, whether the right can be vested only on the ground.
You are saying the right of the riots cannot be vested.
Intermediate, if it is retained land, that portion cannot be also vested because it is right.
How it can be retained?
Yes, my lord, can you consider section 5 once?
You go on section 5.
Yes, my lord. Effect of notification, my lord, can you consider?
Yes.
Upon due publication of a notification under section 4, on and from the date of vesting,
Yes.
the estate and rights of intermediaries in the estates to which the declaration applies shall vest in the state free from all encumbrances, in particular without prejudice to the generality of the provision of clause. Every one of the following rights which may be owned by intermediaries shall vest in the state, namely the right of subsoil, including the right mines and minerals, right in hard bazaar ferries, toll, and other Shariati interest. Pause there for a moment, and my lord can turn to section 4.
Yes, from section 4, from the date of vesting, the
Yes.
right,
Now, my lord, can you
right of intermediary has been vested to the right of intermediary.
rights of estate,
Right of intermediary, including the right to hold heart on a
everything,
particular land.
everything will vest. So, riot cannot, the estate of a riot cannot be vested in segregation with the Shariati interest. Am I clear to your lordship? A right cannot be vested. A property, the estate can be vested. A Shariati interest.
That means, 20 estate. Now, right of intermediary.
Yes, that is section 6.
Of riot.
Yes. Now, I'll come to section 6.
The section 5, right of intermediary has vested to the state.
No, here it does not say so. The notice does not say so. Notice said.
Section 4 says so.
Yes, this notice. Why I am challenging the same, my lord? This.
No, let's come to.
Yes, section 4 says.
All estates.
All
and
estates.
The rights of every.
Estates. The vesting should.
Rights of every intermediary.
Yes, intermediaries will be vest. Estate coupled with interest.
Yes.
What are the interests? My lord, that your lordship will find section 5.
Yes. Section 5.
Effect of notification.
Estates and rights.
These are the. Now, my lord, can you consider section 5, 6.
Yes.
This is the intermediaries retention. Notwithstanding content is section 4 and 5. An intermediary shall expect in the case mentioned in the proviso to subsection 2 but subject to other provisions, subsection be entitled to retain with effect from the date of vesting land comprising homestead, land comprising apartment to buildings, non-agricultural land in khas possession, not being a tenant, such as provided the total area retained by an intermediary under the clause shall not exceed 20 acres, provided further the land retained by intermediary under clause C and petty part of the utilized for the period of 5 consecutive years. These are the non-agricultural land. So,
It's 6-1 to F.
if now, my lord, I have written this land.
Agriculture, homestead, tank fishery, and G is for mill, factory, etc.
Now, this land was written in respect of the where the heart is operating. Yes, heart cannot be. That is the question. This came up for consideration.
Heart.
What is heart? To allow the person to
Heart
occupy.
is nothing but a mode of use.
Yes, grateful to your lordship. Grateful to your lordship.
Yes.
So, ipso facto recording heart does not mean that ipso facto it will be best.
I have a land. I can use
Any mode of user. I am grateful to your lordship.
a building or by running a heart.
Heart. It
But it is a mode of
user. Such the interest.
Now proceed.
Now, my lord, here the notice issued as it was recorded as the heart in the RS record of rights. So, this land cannot be retained.
Where is that decision?
Beg your pardon?
This land cannot be retained.
Yes, in the notice itself. The notice itself is.
Now, in respect of a particular land, where the intermediary used to hold heart, the right of intermediary goes estate to the state.
Yes.
Yes. Estate goes.
Then right
Now,
such the interest will go.
now the right to hold the heart
Yes.
also goes.
So therefore, yes,
Then what remains?
yes, but this is the written land of the intermediaries.
How it can be?
Yes, kindly considers the order.
Unless and until a intermediary is empowered to retain under section 6,
Yes,
he cannot retain anything.
section 69, my lord, kindly call page 69, the order passed.
Now who are you? You are the intermediary or not?
No, it is now I purchased from the intermediaries. We are the after the return. Yes, from the intermediaries.
From the
Yes.
intermediary. Although your right has been vested to the state.
My right retained portion. My retained portion can be vested.
You have no right to retain the land.
That is why, under any clause of law, my lords, Shariati interest cannot be retained. Shariati interest cannot be retained in isolation of the estate. Estate can be vested. Shariati interest cannot be vested. Shariati interest coupled with the estate. When the estate vests, this right also vests to the state. If, my lord, can you pause here for a moment? If a land is there upon which I am running a hut, under the statute, I am entitled to retain 20 acres of land, non-agricultural land, and 17 acres of agriculture. 25. I have retained that land. Yes. I want to retain that land for own purpose. Whether, I put this question to myself, that land was recorded in the RS record of right does disentitle me from claiming that land for the purpose of retention under section 6. It is the land, quantum of land which vests, not the interest. Interest comes when it's coupled with the land. Estate vests. The title.
Your contention is that by executing the B form or return, submitting return, you retain the land.
Yes, that is the order.
Where heart is to be held.
Held.
It is your that heart was retained under section 6. It is your contention.
Yes.
Now, what proceedings initiated under section 5A?
Section 60, page 63, your lordship will find.
That means the land you have transferred to another person.
Yes. Unless until.
Transfer was most probably held not bona fide.
No, it was held bona fide. Held bona fide.
Take a
71, the last portion.
71, last portion, yes.
I am fully satisfied to observe that the transfer is bona fide and order that the land transferred be declared to be the land of the transferees and that of 0.75 acres of the non-agricultural land to be deducted from the retained land of the transferor.
That means your contention is that You are allowed to retain the land where heart used to be held,
Yes.
deducting the 75% land from your retained non-agricultural land.
I am not.
Now what subsequently?
A notice was issued that the notice I handed over.
Subsequently, take us to RS record of rights.
Yes, RS record of right is heart. That your lordship will find at page 73. Yes, judgment of court. Single benches. The proof answer de amake. Now page 77 your lordship will find. Now the dag has been recorded in so many name of the so many persons. You can ask a single bench order that. PK Shaman. Judgment.
What is the plot number?
4529, my lord.
RS.
RS. Page 74, my lord, you'll find. Page 74.
You know,
Your lordship will find. It will Joshua Kedavan. What do you mean that? Yes. 25 and 26. দুটো কপি নেই?
or otherwise, we can be, we said, the authority shall proceed, but no final order shall be passed without leave of the.
Lordship, may I humbly submit? My lord, before filing the OA, my lord, it is crystal clear from the impugned order which is under challenge that they have appeared, they have participated in the hearing proceedings, my lord. And with the instead of waiting for the outcome of the final order, they have preferred to file the.
We will ask your officer to pass.
Lordship already passed, my lord. Final order has been already passed, my lord. And record has already been corrected, my lord.
তো এতক্ষণ চুপ করে আছি কেন?
Your lordship was not asking me anything.
So when we are entering into the merit, then you should have said,
And my lord, the backdrop of the entire proceeding is pursuant to a order passed by the Honorable Division, which presiding over, my lord, the Honorable Chief Justice sitting with my lord, Honorable Justice Hiranmoy Bhattacharya.
Record that these proceedings has been initiated
One
pursuant to the order passed by the division bench.
one
That will suffice our purpose. That these proceedings are initiated on the basis of the order passed by the honorable.
without entering into a merit, we cannot say, without going to the.
Because that is something.
Actually, we shall record the submission made on behalf of the state that final record has, order has been passed.
Not even if, my lord, kindly consider today, even if I satisfy your lordship, these proceedings will be initiated without jurisdiction.
No, you are prayer before us is that you stay the proceeding.
Yes. Now, my lord, if it appears before law and lord that the proceeding has been, then that has been challenged. My lord, kindly consider. My lord, kindly consider whether if it is vested, my lord, kindly consider. If there is no interim order as on this day, the property has been declared to be, record has been corrected. The possession still remains with me because under 10.2 there is no proceedings for taking of possession. Now the proceeding is pending regarding the issuance of the initiation of the proceedings is under challenge before the tribunal. The notice. Pursuant to which
That has
Order
become
has already been
order has been passed. You challenge this order.
yes,
before
if the notice goes by all the subsequent things, I can challenge the same,
We
my
have
lord.
not obtained any interim order.
That was refused. That's why I am before your lordship.
When was the final order passed? Record correction. Final order was passed on
17/11/2023.
17th November 2023. Where is paragraph?
My lord, I have annexed, my lord.
Even
Page
before
23.
passing the
Page
order.
What are the, it was not brought to the notice of the tribunal also? My lord, can you consider?
We will record that, Mr.
No, my lord, the next date, my lord, fixed for the status report obtaining from the BLRO, my lord. That was the first day, my lord, when the interim order was rejected, my lord, and the next date fixed for filing the report, status report from the BLRO.
Then
That,
it was-
my lord, we have, my lord, produced
Status
entire
report?
thing, my lord.
No, the status report was produced and you corrected.
No, status report before the Honorable Tribunal, 3/12/2024. That will the date, my lord. Next date,
Then what
before
is
the tribunal,
3/12?
2024. Last paragraph, my lord, last line from the impugned order.
Challenge to include এই order. এই order টা দিয়েছে 9/1/2024 তার আগে।
Yes.
When you file the original application.
Yes, my lord. The original application was filed on 26.
No date has been given.
You have not given any
No date has been
date
given.
also. When you have filed. Before passing the order impugned in this petition, the final order has already been.
Yes, but if your lordship can kindly consider.
How we challenge it?
Even before,
Once, if your lordship can
filing the LRTT application, my lord, OA application before the tribunal.
till today, my lord, I do not have any access to the documents.
So we will record.
If they applied for the certified copy, because my lord, it is their knowledge that they have appeared and submitted entire documents.
Yes, and our argument is that the non-agricultural land cannot be vested.
A copy to your friend, na? Give a copy.
Non-agricultural land cannot be vested in such a manner.
Said in the order passed by the learned tribunal in 9th January 2024 in OA number.
Yes, take this back.
62/24 of 2022.
এটাই ওনাকে দিন।
This.
But I have another copy that. I have another.
Keep that with you. Give that copy.
My lord, my instruction should be removed.
Instruction don't give.
Acha.
Don't give.
That is why, my lord, I take.
Mr.
Then Mr. Roy will start giving instruction.
Representing the petitioner submits that the subject land was recorded in RS record of rights as art. And subject land is written not it's a land of the petitioner and that cannot be and the estate and the Shariati interest of the land cannot be declared to be vested.
Grateful to your lordship. That is
He submits, yet he submits despite such position of the PL concern has illegally issued a notice under section 51A4 of the West Bengal Land Reforms Act in connection with the.
This is something, my lord. I want to draw your lordship attention.
In connection
Once, my lord.
with the proceedings.
This is, I say, fraud practice upon the court.
Which have been
Issue notice to the recorded rights to appear before me, hearing along with all relevant documents on 17/11/2023 at 12:30 p.m. The final order passed on 17/11/2023.
he submits that the notice.
Now, can you consider how the
all the subsequent proceedings
যশোরকে যে আমাকে খুলে দিয়েছে তাই
যশোরের কাছে আছে
না না
একটা কপি আছে
on the
না যশোর দিলেন তো আমাকে এটা
আমার একটা আছে দুটো দিয়েছি
ঠিক আছে
না একটা যশোর বলছে
such and such and it advocate appealing for the
my lord, this is yes second page, my lord, will find the recorded right was directed to appear on 17/11/2023 at 2:30 along with all the documents.
Yes.
And second order, my lord, can you see when the order was passed?
17th. No, the first order was passed on 10th.
Yes, 17th, 2:30.
17th was the date fix. It is not that on 10th it was passed. They misled.
order passed on 17th.
17.
First order 17th.
I beg to be cut. I beg to be
No,
cut.
ডেটটা দেখতে পাই
You should kindly record one thing, my lord, pursuant to the Honorable Division Bench order, my
Yes, my lord, record that.
passed in the one appeal matter, my lord.
Yeah.
We have proceed with the entire
Did he
proceeding.
mention that order in his order?
No.
DLRO mentioned that or matter?
No.
You say that before the
Why?
tribunal.
My lord, can you record that? It is a submission. It is a submission from the state.
Order does not reflect the state. Order does not.
So
reflect
it is a submission from the state that they are initiating the proceedings pursuant to the order passed in the public litigation.
She committed a problem.
We have insisted her to appear.
আমরা বললে চলে যাবে।
Avoiding this thing when you are not accepting. Yes, okay. কি বললাম? আচ্ছা, submits that the proceedings initiated, the proceedings in connection with the notice was issued has already been disposed of by passing an order dated 17th April 2023.
এই order তো আগেই হয়ে গেছে।
Before presentation of the original application before the learned tribunal. ঠিক আছে। The stop written instruction along with all annexures thereto as produced is taken on me. Since the final order has already been so since the proceeding connection which the notice was issued has already
সেটা চ্যালেঞ্জ করেছি চ্যালেঞ্জ অলরেডি তাহলে may I sort leave or think about this order leave to challenge because according to us it is without jurisdiction.
Let the order.
Yes, get
Yes.
are not inclined to interfere with the order in queue. Consequently, the petition is disposed of. Is disposed.
What you are saying, sir?
because now my contestation is without jurisdiction. This proceedings has been initiated without jurisdiction, so I can challenge before the tribunal in the existing way by taking the
That is your
Yes.
choice.
and one thing, my lord, may I praise subject to question, my lord. Some
This order shall not
Yes.
preclude the petitioner to take appropriate step before the competent authority in accordance with law.
Yes, next.
Great.
Yes, next. Oh, কোনটা চাইছে? You want anything?
may I get back the notification that is a non-agricultural land which I've handed over to your lordship or it will
Oh,
Let
Take
it
it.
be after
after signing the order,
No, no.
take it. Yes, next. Yes,
My lord, I am for the petitioner, my lord.
Please,
My
your
lord,
other-
private service upon the, my lord, private respondent is not, my lord,
Not
if
complete.
not effected, my lord.
Not
Same, my lord.
Yes. Yes, next.
20, my lord, after filing of the writ petition, my lord, he has died, my lord. My lord, today, my lord, I filed the substitution application.
Acha.
20, I am appearing.
7th March, my lord, he has died.
Mr.
20, I am appearing for the PTR or respondent number 5 and 6.
Mr. Learned Ad, Mr.
Mara
Das
gaje.
Learned Advocate appearing for the petitioner prays for an accommodation to take necessary steps in the matter. In view thereof, let the matter go out of the list for the present. Stop. Liberty to notice.
My lord, adjourn for, my lord, today I have filing, my lord, substitution application. Affirming, my lord. So, my lord, fix
Give it
mention. Yeah, as you lords, as you lord,
liberty to mention.
as you lords.
File it, mention along with the application, it will come. Another appearance to the
Advocate and record.
liberty to mention with notice to the learned advocates who have entered appearance on behalf of the respondents. Yes. Yes, 21.
In item number 21, I appear on behalf of the petitioners, but the service is not complete. Well,
Fix. Yes. 22. 22.
22, my lord, I beg to appear for the respondent.
Fix. Same order. Wait. 24. The petitioner is not here. Service. Yes. Next. Same order.
My lord, 24, my lord, I am for the petitioner, my lord.
Petitioner.
Yes.
Your service is complete.
My lord, service is complete, my lord. But state is also a necessary, my lord.
Further respondent number 1.
All right. Come on next week then.
My lord, I have some urgency, my lord. They are raising construction on a state land and which has been given under section 6(3)
He's
in.
appearing for the
I'm opposing, my lord, for the respondent number 1. For the private.
is for the state.
My lord, kindly keep it tomorrow, my lord.
All
Mr. Siddiqui, Mr. Advocate General, everybody is here.
Everybody?
My lord, in this matter, my lord, on behalf of the
See
state.
anybody. We don't see anybody except Mr. Dhar.
Then, my lord, kindly take it up tomorrow, my lord, at least. My lord, I have some urgency, my lord.
Who is for the state?
স্টেটের কে হয়ে আমি কিভাবে বলবো?
Sir, Mr. Talematu Siddiqui is leading.
Sir,
He's on legs, my lord.
state.
on top, some preference may be given, construction risk free. Yes, yes.
Then why should I hear it?
My lord, at the interim stage, my lord had the determination, my lord has. My lord, kindly hear me, my lord. My lord, may I? Dispose of his.
Mr. Dhar, why should I do it?
My lord, this is the second round. It's coming before my lord.
Very good. I grant passed an order either in favor of the state or in favor of the respondent. Once I have expressed my mind, will it be proper for me to take it up?
My lord, my lord,
What do you say? You are so quiet.
I was the private respondent, but I succeeded in the.
You are gauging that which way it will be proper.
I am not responding.
তার উত্তর এভিডেভিট স্টেটেড
Lordship can keep it. Lordship can. I personally have. Lordship can.
then my lord kindly hear.
Or
Then
when I have passed an order in either of the parties' favor, once I have expressed my mind,
since subject to correction, since my lord has the jurisdiction of WPLRT, hearing of that 226 application,
we will release it. You get it assigned tomorrow.
there is no difficulty, my lord. That stage was ad interim stage. My MA application was pending before the tribunal. During that pendency, tribunal has fixed the matter in the month of June. During that period, challenging that order, that since tribunal has not entertained our prayer for ad interim injunction, since they are constructing on that land, and this is a 6-3 land, state has.
So we passed an.
Yes. Finding is, my lord's finding is, my lord, kindly hear, my lord, I'll place my lord's order first. Order to them. Order to bolo, page bolo. Kindly come to page 605. চিঠিটা দেখো, যেটার বেসিসে ইন্টারভিউ হতে অর্ডারটা দেখো। My lord, at page 605, my lord is looking for that previous order, my lord, which is at page 605. My lord, kindly come to page 605, my lord. সুপ্রিম কোর্টের অর্ডারটা পেজ বলো।
On personal ground of one of us, bracket আমার নাম দিয়ে, the matter stands released from our list. Let the matter be placed before the
State's property, central government is the retainee. Somebody else is making construction. বলবে আমি মাইন্ড মেকআপ করি, যেখানে অ্যাসাইন আমি যেখানে শুনতে পারি না সেখানে আমি ইন্টারভিউ। They are unsuccessful before the LRTT.
Mr. Dhar, I passed an ad. Whatever order I have passed, I passed an order. Now, had it been the same, if it is the same matter in which I have passed an order in favor of either of the parties. Today, that order was challenged, was modified or set aside.
Supreme Court has, I'll just only take your lordships to the Supreme Court's order. I'll not place my lord's order. Kindly 612, my lord. Page 612. Volume 3. Volume 3, my lord. Only 2-3 paragraphs, my lord. The short question that arises for consideration is as to whether
Yes.
is as to whether High Court should have gone into the merits of the case when the West Bengal Land Reforms Tenancy Tribunal itself has issued notice and the matter remains pending. That was my MA before the LRTT in connection with my OA. Then, my lord, next paragraph, we are of the considered view that the impugned order is liable to be set aside as nothing more remains to be done by the tribunal, especially when the application is still pending for consideration. We do not wish to say anything on merit as we are inclined to set aside the impugned order with a direction to the tribunal to dispose of the MA within a period of 6 weeks. Now, tribunal has passed an order.
Yes.
Now, tribunal has passed the order. My lord, tribunal has, my lord, entertained my application, my lord, upon giving hearing all the
And
parties, and my lord, the
decided-
injunction, my lord, was refused by the tribunal. That particular order is before my lord.
Yes, this is the second leg of the litigation. Na? It is connected with the same matter, Mr. Dhar. Today we cannot shut our eyes to the order which
Sir,
we have.
kindly record Mr. Mitro's contention.
I have no objection, Your Lordship. I have no objection. Of course, I have complete faith in my lord. That's something.
In previous 3 rounds of writ petitions, my lord, interim order was granted by this honorable court.
Not a
No,
There is
no,
no such order.
no.
You
My lord, since my lord has the jurisdiction, my lord,
do not know today Mr. Mitro may be there. Tomorrow there may be another counsel. The question may be raised that why the honorable court was so interested that it has to hear him. It becomes embarrassing for us. Today he is there, but tomorrow
kindly
another
note,
person
my lord, note their consent. My lord.
go into an adversarial relationship with the advocates. Can we on personal ground of one of us? The matter stands released from our list. Let the matter.
My lord, I have some urgency, my lord.
Today, 12 at 1 o'clock, it will be signed and served. Personal ground, on personal ground of one of us, bole amar naam diye দেবে, comma, the matter stands released from our list. Stop. Let the matter be placed before the Honorable the Chief Justice for assignment before the appropriate Honorable Court. করে একটু টাইপ করে পাঠিয়ে দাও, আমি সই করে দিচ্ছি, একটু ওই 1:30টার সময় সার্ভার সাথে সাথে এসে যাবে না? Yes, next. Next. Line to be বলে দাও।
25, I'm for this.
বসো, তোমার other side, তোমার deliver আসুক। Yes. কেন?
দেখ আমি ভুলে গেছি সব।
আমি
এটা তো তোমার
হ্যাঁ হ্যাঁ
এটা নিয়ে তুমি এতে চলো দেবাংশু অশাক 2016 সিলেকশন
Dr. Patro is my other side. থাক না করবো কিন্তু করতে পারবো না আজকে।
then it will be first week of April
Do that your lordship, পারবো না আজকে ভুলে গেছি।
April first week
আমি তাহলে ওটা বলছি না
second
2015 ম্যাটার
second or fourth
খাই
April
যাওয়ার কথা না
yes
তাহলে কেন
আমাকে আর আমি কোর্টে ঢোকাচ্ছি না ভাই
ফার্স্ট উইক অফ এপ্রিল ঠিক আছে চলে
Lord, I beg to appear for the writ petitioners. Your Lordship, before my learned senior friend begins, one indulgence, we are intending on filing a supplementary affidavit to my opposition.
which one
Item number 26, Your Lordship. Shunanda Goenka versus Neil Vasu.
what happened
Your
You are
Lord,
for the rich petition
yes, yes, yes. Your
not the appellant
No, no, no.
oh appellant is
I'm
not-
for the appellant.
My learned senior friend is for the appellant. I just wanted to inform your lordships that we intend on filing a supplementary affidavit to my original opposition, bringing forth certain documents.
supplementary affidavit in opposition
Yes, to my original opposition, bringing forth certain documents which are absolutely imperative for
you are for
adjudication.
you are for the
I'm for the original writ petitioner,
who is that respondent
Neil Basu.
দেখি ফাইলটা
কি করবো
একটু শুধু
ভালো করে বলো হোস করবো
Mr. Miss জানা না সার্চ you are Mr. you are for respondent number
One, Mr. Neil Basu.
So for this matter is concerned, my learned friend has used his exhaustive affidavit. State only yet to file an affidavit. Twice that direction has been passed. Time has been extended not. I'm taking exception to my learned friend's prayer.
Your lordship,
My learned friend has to then indicate what are the documents.
your lordship, I can indicate it
Do
right
that,
away.
please do that.
Your lordship, I can indicate it right away. However, your lordship, there is subject to correction. There is certain protocols that we as advocates have to follow in order to bring forth certain documents for your lordship convenience. It has to be filed by way of a supplementary affidavit. All I am asking is for 2 days adjournment. I have the copy with me. However, it is not affirmed. It is not even sketched.
Malad, I tell your lordships, if during the hearing, if your lordship feels that he needs certain, Malad,
Mr. Sharnal, we cannot hear it today finally
but time, he should not be given, Malad, there using.
Your
affidavit.
lordship, they are already,
Then I have to
they are already
Malad,
covered
my
under.
learned friend has written a letter yesterday. Kindly have a look at this.
কি বলেছে
Malad, kindly go through it. I'm sorry, I'm not reading it out.
Your lordship, I have no inhibition in reading this out.
Against this gentleman. Who is your client?
My client is Sunanda Goenka.
My client is Your Lordship Neil Basu.
Is the advocate.
He was
the
a
advocate.
student. Yes, I'm appearing for him. He was the original complainant in the case, Your Lordship, and he was also the writ applicant, out of which this matter has arisen.
Now, what document you want to bring on record?
Your Lordship, I can intimate Your Lordships about that. There were certain affidavits filed in connection with another matter by various
We will not
entities.
give you leave to do it. You prepared your own copy at the time of hearing. If we so desired, we will consider Mr. Sannal's prayer.
Your Lordship, however, if one indulgence, Your Lordship, these documents are instrumental in substantiating my case.
So for that, there is another remedy available to you. If you want to bring new documents, you have to
Take leave.
Well, this was not in the writ petition.
Your Lordship, on multiple occasions, my learned senior friend has alleged that this writ has been filed in collusion. However, now when I am bringing such records, he is now objecting to that as well.
What document you are trying to bring on?
Your Lordship, with regard to the documents were filed by UGC and state opposition in another matter, which is not intrinsically linked, but somehow linked with my matter with regard to the qualification of the appellant here.
Very good.
Yes, now my issue, now
That is a matter of record in another proceeding. That is a court's record.
Your Lordship, in
You will place this matter before us, then we will consider whatever is okay.
Your Lordship, one indulgence. Your Lordship, I am submitting this out of my own ignorance. Whether at all I can supply those affidavits without filing an affidavit from my end, Your Lordship, I am a bit vague on that because I have
That stage has not come as yet. You are saying that my defense would be incomplete if I do not bring such materials on record. For that, there is a procedure prescribed. Then you apply under this.
My lord, may I make one submission?
My lord, then kindly grants me the liberty to go through that.
Documents, they obtained an order. We are challenging that order.
My lord, I have little submissions on this. My lord, I was the respondent. I have on appeal before your lordships against an order passed by on the writ petition. Now, my learned friend is the respondent writ petitions. My learned friend cannot ask for, my lord, expansion of the writ petition before your lordships.
Your Lordship, I am not asking
Of
for.
course, what was not before the learned single judge,
Sir,
my learned
Manal,
friend
that
cannot.
will be an issue as in order 41 going to be find additional documents whether we will give.
That's your lordship. That's another your lordship.
So that is why we are asking he would be at liberty to take appropriate steps.
That's your lordship.
Your Lordship, then kindly
It
grants me
doesn't
liberty.
require any, my lord, I'm not. No liberty is required. No liberty is
Grant
required.
any liberty.
It is my ignorance. I have always practiced in the criminal side, Your Lordship. Plead my ignorance with regard to that.
Subsequent hearing চাইছি
একটু সিপিসি টা দাও তো সিপিসি টা দেখে নি
চাইছি অর্ডার চাইছি অর্ডার
আমি তো ফার্স্ট উইক অফ এপ্রিল দিয়ে দিই থাকবে না অন্য অন্য বার কর কি বার করছিস এখানে কাজ করে না এখানে ওয়াইফাই কাজ করে না কোন ওয়াইফাই কাজ করে টাওয়ার কাজ করে না ঝামেলা
Switch is not working.
বুঝেছেন
Your Lordship, if I may, Your Lordship, since Your Lordship,
to apply your mind, there are two procedures under CPC. You go through those two procedures and decide which one will you opt for. One is order 8, rule 9, subsequent pleadings. Another is order 41, rule 27, where both the parties can.
We cannot say we do not know anything about the matter. You read both the provision and take these.
Absolutely, absolutely.
You read the provisions and take necessary.
Your Lordship, in one,
এখন কি হয়েছে?
if I may be able to indicate one aspect, Your Lordship, since your Lordships have
So no affidavit has been filed by the state.
no, Your
Take
Lordship.
these letters.
Your Lordships, if I may be allowed to say something,
What?
Your Lordship, since Your Lordships have indicated that those are court records and
See, don't put the bullet upon our shoulders.
no, Your Lordship, absolutely, absolutely.
Then why you are repeating this? You take appropriate as you are a lawyer.
Yes, yes.
State has not filed. Who is for the state?
Mr. Shishonno Bandyopadhyay. Huh?
Why is state not appearing?
চেঞ্জ অফ লয়ার্স আছে নাকি কিছু? না না লাস্টে না মুখে তো বলতে চেঞ্জ অফ প্যানেল কিছু চেঞ্জ হয়েছে?
নতুন প্যানেলেও তো শীর্ষণ্য আছে।
It's a last chance বলছি।
তো অন্য ম্যাটারে তো স্টেট হয়ে অ্যাপিয়ার করছে।
You have given your reply.
Yes, Your Lordship.
Why you are opposing Mr. Shan? What document he wants to bring? He wants to bring court records on his plea.
No, court. How do your losses know the court records?
No,
They have
that is
they
what-
have to
Your Lordship,
kindly.
that has been
Then
filed.
he has to file appropriate steps according to law.
Mhm.
So let him take it.
Yeah, order 8 rule
No,
9,
but
he can
that's not-
take a leave from us.
This not leave is required, my lord.
Yes, subsequent pleadings.
My lord, subsequently he has to take out an appropriate application.
Not application, he will file a
No,
supplementary.
supplementary affidavit is not, my lord, desired under the law. It's not contemplated under the law.
Your Lordship, I'm asking myself, how am I barred from
I tell you,
submitting?
Suppose he prepares a supplementary affidavit, he will give an advance copy.
My
to
lord, I
you.
tell you, losses, the law of supplementary affidavit relates to subsequent facts. Only the facts which are brought to be recorded.
So that we will argue, Mr. Shanna.
Well,
We
that's
will
your
argue
lordship.
that before us.
Well,
Let
that
him file the affidavit with advance copy to you. We will finish off the matter. What is the use
no,
of
my lord,
that?
I take your losses to this, my lord. This is my submission. Let him take steps in accordance to law. Let him take steps
No,
because
we
I
will
take.
only record that he is praying for filing a supplementary affidavit. We are granting that leave to him. He'll file it.
Well,
with a
that's my
copy to
point.
you.
Your losses.
We are not accepting. Then we will question of determination. At the time of determination, we will certainly
No,
consider.
that's your losses, my lord. Kindly see, my lord. As far as my
Otherwise, Mr. Sannal, matters cannot be disposed because this was extended. Interim order is continuing. Then let us.
I
dispose
tell
of
you,
the
losses. I
evidence
tell you,
let us
losses.
take-
For that, I am not at fault. I am ready to argue even today because
Hmm.
affidavit is complete.
Very
I'm ready
good.
to
Let
argue.
him come with that, Mr. Sannal. We are fixing.
My lord, my little my submission only, my lord. If he wants to come, he has to file an application appropriately so that I can take
Not
exception.
an application. He's coming with a supplementary affidavit to his affidavit in opposition.
My
He's
lord,
not filing an application.
And
That is subject to your, because you will certainly file a supplementary affidavit in reply.
my lord,
Complete
my
your
lord,
pleadings.
supplementary affidavit, my lord, cannot be allowed to be filed in respect of facts which were existing before the filing of the writ
That
petition.
you will understand once you see the documents.
Well, therefore my learned friend will 6 leaves. He has to indicate what are the documents. Otherwise, my lord, it requires hearing. If during the hearing it point out that certain documents needed to be filed by way of supplementary affidavit, then.
Sir, I think we are
But
not being
routine
very-
matter, my lord, this should not be allowed.
Channel, I think we are not being. He will file on his prayer. He says that I give me a leave to file a supplementary.
That's a routine matter.
Exactly.
Well,
Now
that's-
we will not accept a document which we cannot accept, Mr. Sannal. For that you are
Well,
there
this
to
should not be come on record at all. I just
argue that law, Mr. Sannal.
I tell you, then I have to take out the judgment. Supplementary affidavit can be filed subsequent to the filing of the claim or writ petition. If the facts subsequent to this, then supplementary affidavit, provided this is germane to the issue. But if the supplementary facts relates to the facts prior to the writ petition, supplementary affidavit cannot be.
When will you come to
That's during the hearing of the
Right.
petition. So let us proceed. Let my learned friend disclose
At
this.
the time of hearing, we will consider that. What is your
That's
problem?
that's not the process, Your Lordship, as far as my submission.
Your Lordship, if
That should be
We
an
are not-
application.
We are not taking the materials on record. We are granting.
As soon as it is filed, that is on record, my lord.
We will make necessary statements to that effect.
That's my my.
What is your purpose? Whether you want to bring some subsequent pleading
Your Lordship,
in addition to the pleading made in your affidavit in opposition.
Your Lordship, I have not leveled a single.
We
I have not leveled a
are not
single
here to
allegation.
advise anything to you.
No,
What is, since you are saying, what do you want to?
Your Lordship.
Only to bring some document?
Yes, that is it,
Or
Your
you
Lordship.
want to bring some pleading?
Your Lordship, I'll try to clarify.
Your
Your Lordship,
either in form of set of counterclaim as it is done before the,
Your Lordship,
or you are introduce some pleading, along with the pleading made in your affidavit.
Your Lordship, I'll try to clarify. I have not leveled any allegation in this supplementary affidavit. Neither have I expanded the scope of my original affidavit in opposition by way of this supplementary affidavit. Now, what have I annexed? I have annexed
So you want to bring
two or three affidavits. No, absolutely no pleadings, because I have already relied upon the submissions in the original hearing that the appellants did not have any qualification.
While we are not here to advise you.
No,
My lord, I tell you, Lord, the scope of the writ petition, whether during the pendency of the criminal proceedings where FRT has been fell out, can the writ court pass a direction for appointment of an agency?
Yes,
Parallel.
there is
That's
no
the
bar.
scope.
Wait, Mr. Sannal.
I have
Third,
specifically
Mr.
assessed the
Sannal,
conduct
learned
of
advocate appearing for the appellant and Mr. Vishwas and Mr.
Shohomde.
and Mr. Dale, learned advocate appearing for the respondent number 1. No one appears today on behalf of the state respondents, and we have been informed that no affidavit in opposition on behalf of the state respondents has yet been filed. The appellant, you have exchanged those affidavits are
Yes,
already on record. Your reply is on record. Hard Mr. Sannal. Let the reply earlier you filed. Your
Yes,
you filed
reply has
earlier.
been served upon us as well.
The appellant and the respondent number 1 had already exchanged their affidavits. Stop. No one appears on behalf of the state. And we have been informed that no affidavit in opposition has yet been filed on behalf of the state respondents. Stop. As a last chance, the time to file the affidavit in opposition. As a last chance, the time to file the affidavit in opposition by the state respondents is extended for a period of 3 weeks from date. Please the matter for further consideration in the event such opposition is filed on behalf of the state, the appellant would be at liberty to use an affidavit in reply to the same. What 2 weeks could have 2 weeks or 1 week, 1 week could have stop. List the matter for further consideration in the daily supplementary list of this court on 2 weeks. Further consideration on 20 on 19th April. On 19th April, stop. The interim order passed earlier is extended. What interim order did we pass?
My lord, just, my lord, your order dated 18th October 2013.
The interim order passed earlier is extended till the end of our interim order passed earlier is extended till the end of April 2024 or until further orders, whichever is earlier. Stop. The appellant is directed to intimate this order to the learned advocates who had entered appearance on behalf of to the learned advocate on record who had entered appearance on behalf of the state respondents immediately, and to file an affidavit of service on the return. Yes, next.
Lord, may we also serve a copy of this order to the learned government pleader also?
Yes, next.
Your lordship, so leave is granted to file this.
No, no.
Oh.
We have not granted you leave. You take appropriate steps.
In this matter, Lordship, item number 27, I'm for the respondent writ petitioner. I'm led by Mr. Shudipto Dashgupta, sir. He's engaged in courtroom number 29. I'm praying for some time to file the affidavit in opposition, Lordship.
Hard Mr. Guptal and a senior advocate appearing for the appellants. Stop. The learned advocate appearing on behalf of your for
Respondent writ petitioner, Lordship.
which respondent?
Respondent.
Respondent
One,
number one.
Lordship.
There was only one writ petitioner.
Ramesh Malik's.
No, তাহলে তো অনেকজন হবে।
There were more than one writ petitioner.
What is your
Lordship.
name?
My name is the writ petitioner's name, Lordship.
Your name.
My name is Shalini Ghosh, Lordship.
God will appear. Whom are you appearing for?
For the respondent writ petition.
For the respondent writ petitioner,
There
Lordship.
are many writ petitioners.
First one, I think.
না সবাই হই সবাই
For all the respondent writ petitioner, Lordship. Yes.
What is the matter about, Mr. Gupta?
My lord, this is regarding the direction of the learned single judge for publication of publication of the panel, publication of the panel, my lord, which was already done before, and the my lord case relates, my lord, to TET 2014, not recruitment process at all. Therefore, the court travelled beyond the scope of the petition.
Ashok,
There is
senior advocate appearing for the appellant. Stop. The learned advocate appearing for the writ petitioner stroke respondents. Praise for extension of time to file the affidavit in opposition to the application being Can 1 of 2023. Stop. Such prayer is considered and allowed. Let such affidavit in opposition be filed within 2 weeks from date. Stop. Reply thereto, if any, be filed within a week thereafter.
Lordship, kindly, I'm praying for 3 weeks, Lordship.
Then we extend the interim order till disposal of the appeal. কতদিন সময় বুঝে না বুঝতে পারছি। Let the affidavit in opposition be filed within extension of time to such prayer is considered and allowed. Let such affidavit in opposition be filed within 3 weeks. Stop. Reply
Grateful, Lordship.
be filed within a week thereafter. Please the matter for further consideration for regulation with in the daily supplementary list of this court on 23rd April. Stop. The interim order passed earlier is extended till the end of April 2024 or until further orders, whichever is.
Till April.
Grateful, Lordship.
Given you 3 weeks.
Grateful, Lordship.
it will appear on 23rd April.
When did you join?
Lordship, last year I was enrolled in the month of November.
You have to be confident. You're appearing against a senior counsel.
Lordship,
Next time, embolden yourself and come back.
Lordship. Grateful, Lordship.
No, I am for the appeal, I am taking an adjournment or appellant.
2 weeks, yes.
Not.
At 29, I am for the.
I am for the school authority, my lord.
I'm for the appellant. Last occasion, your lordship directed me to file a supplementary affidavit bringing the school resolution dated Lord 29th of school resolution, where my application for transfer on special ground has been turned down by the school authority. I have served the copy. Kindly see the resolution dated 30th September 2022. Agenda number 3, that is in my
Where is the order?
yes. That order I have annexed, but in my memo of appeal, your lordship file. Order dated on 16th of January 2024.
So where is your that
Page 38. Page 38.
38?
Page 40, 38.
Not qualified. What is this?
10%.
কত তারিখে 1/6 না
So this you are not within 10%.
My lord,
Now what is the rule?
yes
Up to 10% of the teachers can apply.
can apply.
So you are not within 10%.
my lord, lastly, my lord, 10%, that point I have not taken, but last application is rejected on the ground of single teacher.
Where is
Shifted. My lord, I have I have subbing that resolution I have bringing by way of supplementary affidavit.
On the ground of divorce, the last application was made.
On special ground, my lord, last application has made. Agenda number 3, your lordships kindly see agenda number.
When was that made? On 1st of June 2022?
Yes.
1st of June 2022. That application on
So that is a fresh application.
fresh application on divorcing ground.
And that has been rejected on single teacher ground.
Single teacher.
Where is that?
Yes, my lord, agenda number 3. Of
You are there. You are there.
Yeah, I am for the school, my lord.
That
Yes,
is
yes.
the that
Well, applied for transfer on 1st June 21 and applied for NOC on 20 June 2022 after lapse of 1 year, my lord.
no. 22. His last representation was rejected, not qualified 10%.
My lord.
Then he made after that you made the application.
Yes, yes.
So you have resubmitted the application on 1st of June.
June 2022.
And they have taken a resolution
On not on
and
30th
what
September.
divorcee ground you have taken a mutual divorce.
Mutual divorce.
Sorry?
Mutual divorce, they have not disputed this fact by this divorce, but they have taken a plea that I have a good relationship with my husband. But my lord, my case before your lordship, my child is with me, visitation right is there. So
So where is your mutual divorce
yes,
petition?
yes, my lord, I have annexed in my main read petition, that is in page number 30.
So you are not yet a divorcee.
My lord,
You are not yet a divorcee.
yes, I am a divorce still now.
Decree granted.
Yes, yes.
Where?
Yes, page 35 and onwards. I have annexed.
Page 35 of the writ petition.
33 is the order and 35 on.
35 of the CAN application, stay application in my read petition also. But my lord, in CAN application.
You have the rules.
Rules.
Special ground, na?
Yes, special ground.
Special ground as per rule 4.
Ito.
Rule 4, no, rule 4C, probably rule 4C or B. Rule 4C. Rule 4C. Female incumbent facing serious problem in attending the school due to divorce or death of her husband.
Where is the amendment?
This is the, my lord, 9th September, probably page, my page number 50, 8 September 2021. And my lord, there is some relaxation in case of a divorcee candidate. Rule 6(2)(e). Single teacher 10% embargo is not applicable if the application is made on the special ground. That is rule 4.
Rule 6(e).
Rule 6(2)(e), sub-rule 2(e). Dispensed with the provision of clause C and D, that is single teacher embargo and 10% rule of sub-rule of application made on ground of mention in rule 4(a) to D.
So where is your resubmitted application?
In the portal.
When was your decree? When was your divorce decree?
In the month of May 2022.
May 2022.
I have application 1st June 2022. After granting my divorce.
No, my lord. Application on 21, my lord.
No, 21 was, she was not a divorcee then.
After the pass order.
That application was made under the ground of my lord distance.
So can you resubmit it, or a fresh representation you can file?
Yes,
under the
portal at any time. It is a random application I can file. So 10%, that is the main point of 10%, that Anup judgment has come and next date I will submit.
So Mr. Hossain, we have passed similar matters.
My lord, what happened, my lord, in the present school, my lord, about 700 students are there, and 7 teachers are only 7 teachers. It's a higher secondary school, my lord, and petitioner is the only teacher of that particular subject, my lord. Physical education, my lord. Only 12th school, my lord. About 700 students, my lord. It's very difficult to smoothly running the school, my lord.
On 2021 academic year, there is 7.
Generally every day to.
We have passed an order in respect of single teacher. Your contention that you will be suffering due to loss of teacher, you show us under which rule you can do so. Show us the rule, we will reject his application. Rule says that single teacher ground cannot be a ground for denial of transfer. Yes, that will be considered by the DI in the light of the circular subsequently given.
May I submit one thing, my lord? In the present case, my lord, after the order passed by the. Yes, my lord.
Mr. Ghosh Chaudhary, learned advocate, appearing for the appellant, files a supplementary affidavit. Let the same be kept on record. A copy.
But in the cabinet statement made, my lord, only 400 students are there. So there is 700 students are there.
You state that in
my lord.
A copy of the same has been handed over.
Yes, my lord, I have received.
Copies of the same have been handed over to Mr. Hossain, learned advocate, appearing for the school, and Mr. Mithro, learned advocate, appearing for the commission. Stop. The parties would be at liberty to file affidavits in opposition dealing with the amendments made in the stay application and the supplementary affidavit. Within a period of
2 weeks.
2 weeks from date. Stop. Replies thereto, if any, be filed within a week thereafter. Stop. List the matter for further consideration under the same heading under the daily supplementary list of this court 3 weeks since.
My lord.
No, we have nothing to say. The commission has not reached the applications and we have nothing to say now at this stage.
We have said parties would be at liberty.
As your lords.
Parties.
Your lordship, my lord, your lordship has considered that order, my lord, single teacher coupled with medical ground.
That the race hotels.
Governments made in
the race parties na bolle, the respondents would be at liberty. Yes, next.
But for the appellant in item 30.
Lordship, Lordship,
But let's say, and item 30 and 31 has been tagged together because both the parties, so far my appeal is concerned, it's a common judgment and order.
Oh,
I'm
that
aggrieved by a
reasonable
portion of the judge.
the
Reinstatement order was passed,
Where is your other side?
but no timeline.
Lordship, the advocate on record on item number 31 is left for his home due to his mother illness. I'm
I
asking
should
for
not
not
stand
this.
also, but kind
not
of things
this week.
next week
Praying for not this.
or this week, Friday. It's convenient, subject to.
First week of April. ওই থার্ড এ করে দাও, থার্ড এপ্রিল, 4th এপ্রিল করে দাও। Yes, next.
As we lost.
দেখে দাও, কি আছে দেখে দাও। হ্যাঁ, তো এখানে কতগুলো হলো? 31
My lord, 32, I am for the appellant, my lord. But this is a transfer of a special ground transfer. My lord, only I am praying before your lordship to consider my application under section, under rule 6(4)D. That is the violation that has been violated by the School Service Commission. That is my only case.
6(4).
Rule 6(4)D.
Where is your other side?
Yes.
My lord, I am for the commission.
He is the answering, he is the answering respondent, my lord.
Medical counsel.
Yes.
চলো, কালকে শুরু। Come tomorrow.
Lordship.
Come.
My lord, regarding my lord, item number 16, my lord. Under compelling circumstances, I mentioned the matter before your lordships. It is my lord, your lordship was pleased to give direction, my lord, matter to appear after 2 weeks, my lord. At the time of calling, my lord, no one there, my lord, for the petitioner.
Then we do, sir.
My lord, urgency, my lord, there is urgency. I was busy in the honorable court, another honorable court, my lord. Urgency is that, my lord, is matter recruitment of fire operator. We challenge the
So
recruitment.
you do not bother to appear, so urgent that you don't bother to.
No, my lord, I was engaged before the honorable.
You don't have any juniors.
My lord,
You
they,
do not know who was there for
my
the
lord,
other side.
they missed the my lord list.
Huh?
Today they missed the list. I prepared and Mr. Pathasarathi
Other
Bhattacharya.
side,
No. But we served. Again, I shall serve, my lord.
not this week করে দিও। ওই মঙ্গল
Oblige, my lord. Oblige, my lord. 16, item number 16. Oblige, my lord. Obliged.
I appear for the backward class commission.
Yes.
Lodge. Well, I beg to appear for the National Commission for Backward Class. State can make their own list. Millard, I beg to appear for the National Commission of Backward Class. Millard, as far as my submission is concerned, Millard, I will try to restrict myself, since this is a public interest litigation, Millard, and the challenge is to the 2012 Act, Millard, and subsequently there have been amendment in the Constitution, Millard. Two basic amendments are there, Millard. One, as far as Millard 338B is concerned, and then the 105th Amendment, which gives the state the right to prepare their own list. So, Millard, as far as the legal aspect is concerned, Millard, I will start my submissions from there, and then from there I will make inroads as to the reason why I have been impleaded. Because, Millard, I have been subsequently impleaded in this matter, Millard, because my understanding is that your lordships intended to know that what are the parameters, because the question is the parameters which have been followed and what is the reasoning behind creation of OBC-A and OBC-B. Now, my lord, how they came to this conclusion, what was the field report, and as per the Mandal Commission as well as Indasani's case and the other guidelines which have been put there, whether they have been followed or not. Now, my lord, as far as I am concerned, the question may arise that, my lord, the state is entitled to have their own list and maintain that. Now, my lord, my salvation is only in 338B as far as that they have to consult me. Now, my lord, my understanding of the statute is this, my lord, that by way of 105th Amendment,
this particular right was not taken away. If my lord kindly allows me, my lord. And secondly, my lord, this is my first branch of submission. And second branch of submission is this, that, my lord, whichever castes and communities were included, I would use communities, my lord, caste is not there, my lord, right? Whichever community was included, my lord, then thereafter recommendation was made by the state government to the central government, that is, to include them. So there came our prerogative to understand that what is the reasoning, the parameters, and the research behind coming to a conclusion that these communities belong to the other backward classes. And from there I find a window to state and submit before my lords that what problems and what discrepancies rather we found, and for which we have a right under 338B as a civil court. So under those, in order to include that, when they came up with this recommendation, we had given them several letters, putting blatant, crystal questions that what are these, how you have come to this conclusion, and what are the parameters being used by you. And because the reasoning given by them and the recommendation given by them were wanting in proper particulars. So, my lord, that will be my second branch of submission. Apart from that, my lord, then there are certain judgments, my lord, which are there, my lord, that a particular reservation cannot be on the ground of religion, and the priority cannot be there. And if it is found that without any other parameters or guidelines or basically the inquiry not being made, just on the basis of certain particular religious community has been given this benefit, then, my lord, that is liable to be struck down. Though that is not my statement, that is what the law says, my lord, and the Honorable Supreme Court. So that will be my third branch of submission, my lord. As far as judgment is concerned, I would ask for leave, your lordship, my lord. My learned friend will place it, my lord. We will not take much time. We'll just give the paragraph. Now, my lord, so, my lord, first, my lord, I come to my first branch, my lord. My lord, 338B, if I'm allowed to place before my lords, though, my lord, it has been placed. If my lords, I had one copy of the. I'm grateful, my lord. Now, my lord, if my lord kindly comes to 338B, my lord. Now, my lord, if my lord takes 338B, my lord, if my lord kindly comes to 338B9, subclause 9, my lord. Yeah. My lord, it says, my lord, the union and every state government shall consult the commission on all major policy matters affecting the social and educationally backward classes. This, my lord, was the, my lord, First Amendment, my lord. Subsequently, there too, my lord, the 105th Amendment provided that nothing in this clause shall apply for the purpose of clause 3 of Article 342A. So, my lord, the first is that the state government and, my lord, the union government is under an obligation to consult us as far as, my lord, educationally backward classes and forming of major policies are concerned. Now, my lord, the proviso says that it will not apply for the purpose of clause 3. Now, my lord, may I take my lord to 342A? Lordships will kindly come, and that is subclause 3. So 342 subclause 3, if my lord allows me to, my lords allow me to read it. Notwithstanding anything contained in clause 1 and 2, that is 1 and 2, my lord, every state or union territory by law prepare and maintain for its own purpose a list of socially and educationally backward classes, entries in which may be different from the central list. So, my lord, the statute in its wisdom does not exonerate the state of the liability or the obligation which has been cast upon the state as per 338B, my lord, 9, which says, my lord, again, at the cost of repetition, my lord, the union and every state government shall consult the commission on all major policies, matters affecting the socially and educationally backward classes. Now, my lord, reading it once again, my lord, 342, my lord. The exception is notwithstanding anything contained in clause 1 and 2, every state or union territory may, by law, prepare and maintain for its own purpose a list for socially and educationally backward classes, entries in which may be different from the central list. So, my lord, it may be central list. They are within their rights. They can prepare a list, which they have done. That is OBCA, OBCB, and they have been under a particular policy and under that act, my lord. But the obligation which has been cast upon the state as far as 338B is concerned, that has not been followed. And the statute in its wisdom, my lord, even that 105th amendment does not exonerate them of this particular obligation. So, my lord, if this is taken into consideration, my lord, we in unequivocal terms have stated in our affidavit that such consultation was not done. Now, my lord, 2018, my lord. My lord is on 2018. My lord, I'm coming. My lord, I'm coming. Now, my lord, therefore, my lord, I come to my second branch of submission, which is interrelated. Why I am, my lord, as far as 2000, my lord, if my lord says this is with regard to 2012, whatever happened in 2018, and subsequently, even in taking into consideration into 2021 105th Amendment, how does it become an obligation upon them? So, my lord, what I'm humbly trying to submit is this policy is continuing. Now, my lord, that is why I tried to impress at the very outset that over here, I am more like a performer respondent whose presence is needed before your lordships to basically bring on record certain facts that whether the policy, because the statute in its wisdom, OBC, my lord, nobody is against classification of communities and support given to them under the constitution which has been provided. But if it is not done according to the parameters, and if the obligation which is cast upon the state and the commission is not done, there lies the problem. And that was not done.
That you have repeatedly written to the state asking for the parameters.
My lord. My lord.
Raise that first.
My lord.
And secondly, please explain yet why you chose to include these names, these lists, these very classes in the National Commission. You have included them.
Well,
not all.
Not all. Some, my lord, and not all. And, my lord, therefore, they have been.
Classes have been included. Any idea? Ask your junior to find out. In the meantime,
how many
you place the letter.
My lord. My lords will then lordship.
After the state classified, recommended to you for inclination. What questions did you ask them?
My lord will kindly see. My lord will kindly come. If my lord kindly comes to my affidavit. Now, my lord, first, so, my lord, we have given a prelude as to what happened, which my lords are aware of, which starts from paragraph 6 and the subparagraph. How it is scintillating that how one particular community in obtained numbers have been included. Now, that is paragraph 6, which we have stated at page 5, and its subparagraphs.
So the facts.
Yes, my lord. If my lord kindly sees, allows me to read, my lord.
Please don't read those facts. They're already there before us. Kindly come straight away to the paragraph.
Then, my lord, will kindly come to paragraph 13.
13.
Yes, my lord. Here, my lord, is our submissions where we have categorically stated the letters and the correspondences which we made in the light of the discrepancies found by us when recommendations were made to us. My lord will kindly allow me to read, my lord. Subparagraph A, my lord. Government of West Bengal Backward Classes Welfare Department wide letter dated so and so and letter as well as letter dated so and request for inclusion of OBC castes communities in the central list of OBC. Copies of this recommendation are at page 24. Now, my lord, I will,
Last time, 2018 and 20, not before that.
my lord, as far as our affidavit is concerned, my lord, it is for 1820, my lord. Because, my lord, we'll kindly see that act, that particular insertion is by way of amendment was in 2018. Before that, my lord, the act did not, the constitution, that particular 338, with my lord, kindly.
Did not even include before that.
No, my lord, it was not included. Yes, my lord, it was not included. If my lord kindly goes through that amendment.
Did not include. We are aware of the amendment.
Yes, my lord. So under those circumstances, they were under no obligation. Because 338B came into existence on 15/8/2018.
What we want to know, Mr.
Lordship.
Is as to whether prior to 2018, was there any request from the state government after 2010, 2011, 2012 to include those 77 classes?
My lord, I will have to take.
Please do that.
My lord, because questions note kar lo. Because, my lord, off the cuff, my lord.
Before 2018,
I bowed.
has it happened or not?
I bowed.
Or have you included?
I bowed.
Post 2018, the act came into the constitution got amended. They were required for they required to consult you. So then they asked you to include the 18 class. That much I can understand.
I bow. Now, my lord, what I am trying to humbly impress upon your lordships is that even in 2018, here comes my window to submit before your lordship, even if this matter is of 2012, challenges with regard to something prior to 2018, my lord. But since I have been made a party, my lord, what I am trying to very humbly submit before your lordship, that when they recommended this in 2018, what were the questions which were raised by us before them? And we could not get any cogent answers thereof. Now, my lord, will kindly see. I'm reading, my lord. Page 14, paragraph 13. Copy the page 15 left.
So first letter is in page 24.
My lord, page 24, my lord. My lord, yes, my lord. That is at page 24, my lord. That is my lord, R1, my lord. Then my lord will kindly come to
notified OBCs.
Yes, my lord. Then my lord will kindly come to the next page, B, that the answering respondents have conducted a field inquiry on and from February 25, 2023 and February 26, 2023. Copy of the communication dated February 24, 2023 is annexed, my lord. So we also made a field inquiry regarding, my lord, page 15 of my affidavit, my lord.
Oh, you're reading the affidavit.
My lord, I'm reading, my lord. I'm going thread by, my lord, one to one. Then I will come to the annexures, my lord. Just not to save my lord's time, whichever annexures lordship will deem it fit and proper, my lord, I will place that annexure. Because annexures are voluminous. I'm just giving, my lord,
you conducted an independent field.
Yes, my lord. I conducted a field inquiry, my lord. That is annexure P3. Then, my lord, that a review meeting was held on February 25, 2023, followed by another meeting on March 21, 2023, my lord. After that review meeting, the Department of the Backward Classes Welfare Government of West Bengal submitted a written response via its letter dated March 16, 2023 to the queries raised in the meeting dated February 25. Now, my lord, next paragraph. Thereafter, a notice was issued on March 14, 2023 by the National Commission to the State of West Bengal, followed by a review meeting held on March 21, 2023. The minutes of the review meeting held on March 21, 2023 for taking evidence on the subject of welfare measures undertaking to secure representation of OBC in employment and admission under the state government of West Bengal was forwarded to the Backward Classes Welfare Department, Government of West Bengal. During the meeting, the National Commission of Backward Classes held on March 21, 2023, Honorable Chairperson, member of the Secretary and Commission raised numerous queries in respect of the issues of reservation for, I'm coming to the next page, OBC in the state of West Bengal and the status of allotment of UGPC seats of medical under All India quota, state quota. The answering respondents directed the state of West Bengal to mandatorily furnish the requisite replies, records, and actions taken on the minutes of review meeting held on March 21, 2023 and on April 28, 2023, failing which the National Commission would have to exercise the powers of civil court under the clause 8 of Article 338B of the Constitution to enable their presence. The minutes of so and so is now, my lord, I come to F. This is very important, my lord. F is, my lord, during academic year 2021, my lord, paragraph, page 16, paragraph 15, my lord. During academic year 2021, total 3575 of the West Bengal undergraduate medical MBBS counseling seats admitted. Total 3351 government quota seats of admission. Now, my lord, OBC was 731 OBC. OBC A. Now, my lord, I coming to the main again, how many in OBC A, maximum number of one particular community were inducted. That are out of 35 castes, my lord, 35 were, OBC 1 if my lord kindly sees, initially in OBC A, my lord, now, my lord, will kindly see OBC A 457, OBC B 263, and other OBC 11. Then, my lord, then during academic year 2022-23, total number of West Bengal undergraduate medical MBBS counseling seats admittedly 4081. Admission was made to 3414, out of which OBC were 868, OBC A 585, OBC B 282, and OBC 1 and other OBCs. Now, my lord, then again it comes, my lord, will kindly come to the last but 4 lines of that page, page 16. During academic year 2021 and 2022, total 820 of the West Bengal postgraduate medical MDs counseling seats admitted, out of which 146, OBC 146, OBC A 95, OBC B 48. Now, my lord, what I am trying to impress upon, my lord, that OBC A, what was the quantum of the community belonging to the minority, Muslim community, and B, my lord. Now, my lord, so what happened, my lord, if I'm allowed to come to the next page, my lord. Postgraduate medical MD counseling seats admitted 977, out of which OBC 191, OBC 120, OBC A was 129, OBC B was 56, and others. Other OBC are persons belonging to the OBC category took admission through NRI quota or management quota on the private medical college. The reserved category, that is OBC candidates who are selected on the same standard as applied to UR candidates, are adjusted against OBC quota. So we asked this query by our letter. Now, my lord, subsequently there to, my lord, what happened? Then, my lord, we come to the criteria which they introduced on their own in order to understand which community. This is, my lord, G. The National Commission for Backward Classes noted that the caste identity, either caste certificate or any relatives having blood relation with the applicant from parental side and proof of such relations, genealogical tree or chart, or copy of the old land deed specifying community name in the document are also options. Now, my lord, what has happened? How they have created the certificate, my lord? If a person comes and says that one of my blood related person is an OBC, so automatically he'll be given. If he shows a particular document where his community has been described, so those categories were also introduced. So we question that category by that particular inclusion by our letter, my lord. Now, those guidelines are at page 122, my lord. That is at page 122. My lord, we also saw these guidelines, which is something new, my lord. Then, my lord, next, my lord, that the representative of the government of West Bengal deposed before the Hon'ble Commission that the West Bengal Commission of Backward Classes 1993 prepares its advice on the basis of report of Cultural Research Institute. Representatives of West Bengal's government could not convey to the Commission about the mandate of Cultural Research Institute with respect to research work and study for inclusion of any caste community in the state list of the OBC. So, my lord, they said, my lord, that CRI has conducted, but they could not answer as to what was the mandate followed, my lord. Now, subsequently, my lord, page 18, Millard, I, Millard, which is very important, that the representatives of the government of West Bengal deposed before the Honorable Commission that the clause 9 of Article 338B of the Constitution of India, government of West Bengal, didn't consult on any major policy matters affecting the socially and educationally backward classes, Millard. So, Millard, after 2018 also, Millard, they have not consulted. Then, Millard, if my lord kindly comes to the next paragraph, J, Millard. Now, Millard, may I come to the next paragraph, Millard? Then, may I stand, Millard? The same page, Millard, J, that the National Commission for Backward Classes, vide its letter dated September 6, 2023, called upon the Chief Secretary, Government of West Bengal and Secretary of West Bengal State Commission for Backward Classes to file its affidavit and written submissions along with evidences and documents record data in support of determination made by the West Bengal Commission for Backward Classes of social, educational and economical backwardness of the list consisting of 87 caste communities, 83 caste communities for press inclusion and 4 caste communities for amendment of nomenclature incorporation of similar caste communities, in which approximately 73 caste communities of Muslim sent to the National Commission with a request to include the said caste communities as backward classes in the central list of OBC for the purpose of Article 15.4 and 16.4 of the Constitution of India. So, my lord, in my respectful submission, my lord, it was glaringly ascertained by us that it was glaring from the document that one particular community was stealing a march over the other communities, and what was the basis of recommendation we could not find. Now, my lord.
It's all in 2023.
My lord, yes, my lord.
And are these in respect of the communities that were included in 2010 and 11 also?
My lord, as far as we are concerned, my lord, off the cuff, my lord, I am taking instructions, my lord, because the instruction here before this is from 2000.
Juniors to go outside from call, please go ahead and do it.
My lord will give me 30 seconds, my lord, let me.
Yes, carry on. Please carry on in the meantime.
Any, not consultation, but inclusion.
You carry on, Mr. Trivedi.
Lordship, I apologize, my lord. Now, my lord will kindly see. Now, my lord will kindly come. Then, my lord will kindly see. Now, my lord, K. The National Commission for Backward Classes, vide its letter dated October 16, 2023, December 15, 2023, and December 22, 2023, issued notices to the state of West Bengal and the Cultural Research Institute. You know, because they said that the Cultural Research Institute was conducting these inquiries and investigations as to why it has been recommended. You know, that is at R9, which we have said. What I'm trying to point out very humbly before your lordships, that as after 2018, whatever recommendations were made to us, we included some of them. I will show that list, that is there, Millard. But, Millard, what we could find, that the criteria which they have applied, they could not satisfactorily answer to our queries, because we wanted to deliberate on the process which was followed and who made these inquiries. And we could not get a positive answer to that. This is what we are trying to very humbly submit before.
To ask them what is the status of CRI, what is the answer that you got?
My lord, is here, my lord. I will try to place it before my lord, one by one, my lord.
And what was the reason for accepting some of them? Your reason for accepting some of the castes which were forward?
My lord, in my respectful submissions, my lord, what happens is,
that
though I'm getting instruction, my lord, but what I have understood from brief reading, my lord, there cannot be this particular aspect, my lord, that all of them, all the communities, because some communities are akin to the communities which have already been included, or where they have followed certain parameters and criteria. All 100 recommendations cannot be, my lord, such that they are bogus. what is we are on, my lord, how the major recommendations. And when we include, we don't include only Muslims, we include Hindus also, whoever have been recommended, finding the criteria, my lord. That we have stated, my lord. I'm coming. Wait, aage dekhiye, देखो, my lords will kindly come to page 57, my lord.
57.
My lord, of the affidavit. No. My lord, we kindly see we have given a list which starts from page 57 and goes on till page 61. And my lord, the minutes start from page 47, which this list forms part of. Now, my lord, these are the communities, my lord. The state list of backward categories, my lord, and central list of it. And my lord, this particular minutes are there, my lord, pursuant to our review meeting, my lord, which we have stated in paragraph 50, page 15, my lord. Sir, may I be allowed, my lord? This is, my lord, if we have stated about this particular annexure, this minute, at page 15, paragraph.
So, Mr.
C.
Trivedi, kindly come to page 57.
Lordship.
You have given state list of more backward category
My lord.
A. That is Abdul Muslim.
My lord.
The state list of backward category B, Boisho Kapali.
My lord.
Now, central list of OBC, there is no categorization in OBC under central list?
We don't have any categorization. In OBC, central category, we don't have. My lord, this is central list of OBC for the state of West Bengal.
You have not categorized.
You have not
My lord, we have not categorized. Central list, we have no category. We have no category.
You just said there are other backward classes.
My lord, whatever is recommendation, we find it proper, my lord, according to our.
In this year.
Now, my lord, may I allow to place this report of the CRI, which is very comprehensive. Starts at page 47, my lord. My lord, may I read from page 47, my lord, second paragraph of the review meeting. At the very outset, Honorable Chairperson, National Commission for Backward Classes, welcome the members, so and so. Thereafter, on direction of the Chairperson, my lord, I start from the 5th line, my lord. The representatives of the Department of Welfare of Backward Classes, Department of Medical Education and Cultural Research Institute, Government of West Bengal, gave a brief outline of the issues of which the sitting has been convened. Thereafter, Honorable Chairperson and members raised numerous queries with respect to the issues of reservation in the state of West Bengal, inter alia covering the following issues. Reservation policy of the other backward classes, OBC, in the state of West Bengal. Procedures laid down in the state of West Bengal with regard to inclusion of Muslim communities in the state list of OBC, i.e. category A, more backward, and category B, and role of Cultural Research Institute. Reservation of medical admissions for students of other backward classes in All India quota scheme of MBBS, BDS, so and so, contributed. Determination of creamy layer limit amongst OBC, establishing equivalent of post for the employees of PSU, etc., as per post of the state government. After obtaining concurrence of the commission, written replies and other related documents were placed on record. Representative of Government of West Bengal responded to the queries raised by the Honorable Chairperson and the member of the commission and assured to send written replies to the queries, the replies of which were not readily available. Now, my lord, representative of the West Bengal government deposed before the Honorable Commission that in 1994, my lord, this is now, my lord, this is what they have stated, my lord, which already lordships have gone through, my lord. Now, my lord, will kindly come to page 50. Lordships will kindly come to page 50, my lord. Well, page 50, my lord, second paragraph may I be allowed to read, my lord. Lordships have got page 50?
Yes.
So, my lord, may I be allowed to read, my lord? The National Commission for Backward Classes find that the West Bengal Commission for Backward Classes has examined the matter and recommended the Kasai should remain unchanged in the central list, whereas Qureshi in West Bengal doesn't fulfill requisite criteria in the West Bengal OBC list, along with the Kasai government of West Bengal passed in the cabinet meeting regarding to recommend Qureshi class to get the reservation benefit from the Union Cabinet only. In this regard, on 15/12/2017, Government of West Bengal sent proposal to the Chairperson National Commission for Backward Classes to provide the reservation benefit to Qureshi class for the central list of OBC only. The recommendation of the said West Bengal Commission for Backward Classes has been accepted in the meeting of the State Cabinet. The National Commission for Backward Classes note that one hand, the representative of Government of West Bengal deposed before the Honorable Commission that total 22 points are assigned for determining the backwardness of any class. 12-point weightage is for socially backward, 6-point weightage is for educationally backwardness, 4-point weightage is for economically backwardness. On the other hand, the National Commission for Backward Classes find that despite of socially, educationally and economically advanced class, that is Qureshi, has been recommended by the Government of West Bengal to get the reservation benefit from Union Government. Thereafter, Honorable Chairperson and Honorable members of the Commission raised numerous queries with respect to provide the reservation benefit to Qureshi class for the central list of OBC only. In this connection, the representative of the Government of West Bengal couldn't give satisfactory reply to the Commission. Now, my lord, it is a voluminous, very, my lord, but my lord, this is what we could find. That recommendations were being made impromptu without even following the guidelines which they are championing for. Now, my lord, will kindly come to page 51, the bold portion. Thereafter, my lord, I am reading with my lord's permission. 51.
Yes.
51. Thereafter, on consideration of the materials made available to the Commission, including the statement and documentary evidences adduced, the reports of the field study and benchmark sample survey conducted by the Cultural Research Institute, submissions made in course of hearing and applying all factors and parameters for determination of social, educational and economic backwardness of a class of people to the state of West Bengal, the observations of the Honorable Commission are as follows. The Commission expressed their displeasure over the unpreparedness of the representatives of CRI and Department of Medical Education, Government of West Bengal. Honorable Chairperson directed the representatives of CRI and Department of Medical Education, Government of West Bengal to carry out proper homework on the subject matter next time they are called upon to tender evidence before the Honorable Commission. During deposition, the Honorable Commission, the representative of West Bengal government, representatives of Government of West Bengal couldn't convince to the Commission, spelling is to the Commission about mandate Cultural Research Institute with respect to research work for inclusion of any caste community to the state list of OBCs. This is what had fallen from your lordship. This is what I'm trying to place. The Commission is of the opinion that the converted OBC Muslim constitutes majority of the state list in backward classes. According to the Commission, recommends to the state of government to revisit the state list of OBC, especially converted Muslims. The Commission may be appraised about the caste communities which are converted from Hindu to Muslim, because, my lord, they are championing for the cause, my lord, that there is a converted, but there is no research to that aspect. There is no research to that aspect. They are trying to say, Millard, that since the people who are belonging to the OBCs or to the backward classes who have converted, and therefore they have been given this benefit, Millard. But this statement made by them is not supported by any research which they could put on table as far as we are concerned.
Mr. Dotto, what is the, Mr. Dotto, what is the status of CRI, Cultural Research Institute?
Of the university.
Is it of the university? Yes. Or is it part of the backward classes commission?
No, I'll take
I think
instruction.
your person is there.
No, I'm told me it is a statutory body.
Under which statute?
Yes, that I find out under the backward class community, backward class department. Statute
Because even the National Commission is repeatedly asking you, from what we find in document place,
yes.
Who, after all, what is the authority of the CRI? Constituted under a statute or what statute we want to know? Yes, please carry on, Mr. Vedi, in the meantime.
Millard, may I? So, Millard, what I am trying to impress with
Continue.
Survey report. Please carry on, Mr.
Millard. Now, Millard, will kindly come to page 60. Millard, I'm just, without wasting further time of my lord, just, Millard, I'm trying to point out what is scintillating me, which is appealing to me, Millard, why it is a communal reservation according to our understanding, Millard. And because, first of all, Millard, there has been no following of no criteria. There has been no research. Nothing of that sort. And CRI has been saddled with the responsibility, who were totally unprepared. They could not tell us as to why and what is the criteria has been followed and the guidelines as provided. Now, Millard, will kindly come to page 61.
64.
61, Millard. Millard, I'm trying to rush through because now Millard, since some questions have fallen from my lord, I just want to answer that. I don't want to be repetitive, Millard.
Yes, please.
My lord, will kindly come to page 61. My lord has cut to. Now, Millard, will kindly see the state list, that the bracket, Millard. That state list of more backward category A. Lordships have got it.
Yes.
75 Muslim castes, 73 Muslim castes have been included out of 81. As far as category B is concerned, 45 Muslim class out of 98. And out of 98. Now, Millard, as far as we are concerned, Millard, of the state of West Bengal, we have included 45, 98. But, Millard, if you, my lord, sees 45 and 73, maybe out of this list, 45 containing both were genuine according to us, and we have also made our research, which I have pointed out, that we have also gone to the ground level. So it is not that we are trying to ostracize someone just being Muslim, Millard. We have not done that. We have included OBCs who are belonging to the Muslim community. But, Millard, the overzealousness of the state in dividing them as is more backward and less backward, and coming to that conclusion without any research any parameters, nothing they could place. So, my lord, this is what we are trying.
So you are saying that 45 out of 98 may also be there in the state list,
Yes,
which was included in
yes,
post
my lord.
2010.
Yes, my lord. My lord, that.
And this is based on your independent research.
Yes, my lord. Because as far as when, my lord, 18, when it comes to 2012, we are not in the picture. 18, we are in the picture. When 18 came, then also we could see that there were discrepancies, which is what I am trying to impress upon your lordship very humbly. That, now, my lord, if that discrepancy is there post 2018, it has come to light. But prior to that, there was no reason how it will come to light, my lord. Because we have no knowledge about it. Now, my lord, then.
No, what state list 45 Muslim castes out of 98. This you totally adopted.
No, my lord. What?
Central list of OBCs for state of West Bengal. That is same as column 2, 45 Muslim castes out of 98 castes.
Yes, my lord. That we adopted. Our.
You have not adopted anyone from the category A73 Muslim caste.
No, my lord. My lord, we have taken both, my lord. In my understanding, my lord.
So cumulative is 73 and 45. From that you have taken 40.
Yes, my lord.
That is
yes, my lord. That is right. Then,
And some of them, according to you, may be from the lists of 2011, which is the subject matter.
Yes, my lord. That can be, my lord.
So you have in fact conducted independent research of
Yes,
your own?
yes, my lord. We have stated that on oath, my lord.
Please read it out.
My lord will kindly come to again paragraph 13. Paragraph 13, my lord. 13B, my lord. Paragraph page 14 and page 15, if my lord kindly comes, paragraph B, my lord. That the answering respondent had conducted a field inquiry on and from February 25, 2023 and February 26, 2023. Copy of the communication dated February 24, 2023 is annexed as R2. Now, my lord will kindly find R2 at page 37. It starts from page 37. Well, this is the electronic mail, my lord.
Page 30.
And 38, my lord.
Hansraj Gangara.
And my lord, then from 40 starts the entire report in Hindi, my lord.
An official detailed
Then the report is there. The English version of the report is at 44A. That was conducted on 25/2/2023. 44A.
So this 45 Muslim castes entirely on the basis of your independent research on 25th February 2023.
Well, we are not at cross purposes with them, but we made our own inquiry because it was, my lord, we found that whatever recommendations they have given, which I read out to your lordships at page 50-51, my lord, that those inquiries were made, and then after that also we found that there is no basis. Then, my lord, then after that, my lord, the review meeting was held, which was followed by another meeting, which I placed before my lords. The review meeting takes place. Then, my lord, will kindly come to page. Now, my lord, will kindly allow me to place page 62. The commission's view, my lord. My lord will kindly take up page 62, my lord.
Yes.
Upon. My lord will kindly see, keeping in view of the above, the commission is of the considered view that, my lord, that particular segment. If my lord kindly comes to the bold portion. My lord, let me read from the top, my lord, otherwise. Page 62. Lordships have got page 62. My lord, may I read, my lord?
Yeah,
Just under. May I read, my lord? Page 62. Page 62, Dada.
Yes, please carry on.
My lord, may I read, my lord?
Strongly recommend.
Keeping in view of the above, the commission is of the considered view. After that, Article 15, subclause 4, 15.5 and 16.4 expressly conferred power on the state to identify and declare the list of socially and educationally backward classes. 3 new articles, Article 342A, 366 and 338B have been inserted in the Constitution. Whereas Article 338B has constituted the National Commission for Backward Classes, Article 342A has dealt with the central list of the socially and educationally backward classes, commonly known as other backward classes, and Article 366 within bracket 26C has defined the socially and educationally backward classes. The legislative intent at the time of passing of the Constitution, so and so amendment, was that it deals with the central list of the socially and educationally backward classes. It recognizes the fact that even prior to the declaration of the central list of 1993, several state union territories are having their own list, UT list of OBCs. On August 18, 2021, the Honorable President had granted the assent to the Constitution's 105th Amendment Act and empowers state and union territories to identify and specify the socially and economically backward classes. This is what I was submitting at the very outset. Then, Millard, the Commission strongly recommends that all those decisions on the major policy matters affecting the socially and educationally backward classes of the state government prior should be struck down, in which the National Commission for Backward Classes had not been consulted. On consideration of materials made available to the Commission, including the oral statement and documentary evidences adduced, the report of the field study and benchmark sample survey conducted by the Cultural Research Institute, available on the website of West Bengal Commission for Backward Classes, submissions made in course of hearing and applying all factors and parameters for determination of social, educational and economic backwardness of class of people of the state of West Bengal, the Commission is of opinion that the converted OBC Muslim constitute majority in the state of list of backward classes. According to the Commission, recommends to the state to revisit the state list of OBC in which Hindu castes are converted into Muslim religion. The Commission may be appraised about these caste communities which are converted from Hindus to Muslims to the state of West Bengal since 1993 to 2023. Now, my lord, the entire recommendation thereafter, my lord. Now, my lord, if my lord kindly comes to page 63, last paragraph, my lord, may I allow it be? The National Paragraph 7, my lord, subparagraph 7. The National Commission for Backward Classes note that on one hand, the representative of the government of West Bengal deposed before the Honorable Commission that total 22 points were assigned for determining the backwardness of the class. 12-point weightage is for socially backwardness, 6-point weightage is for educationally backwardness, 4 points weightage is for economic backwardness. On the other hand, the National Commission for Backward Classes finds that despite of socially, educationally and economically advanced class, i.e. Qureshi, has been recommended by the government of West Bengal to get the reservation benefit from the union government. In this regard, Chief Secretary, Government of West Bengal is hereby directed to produce cabinet note and other relevant files regarding Qureshi class before the Honorable Commission. So, Millard, what I'm in a cursory manner, what I'm trying to place before your lordships very humbly, Millard, that once they are saying that there are certain parameters which they are following, but Millard, that is not the fact, Millard, which comes to light.
Now, what are the parameters do you follow?
My lord, the parameters which we follow, my lord, are, if my lord kindly comes. If my lord kindly sees.
In page 62, you showed us that Commission recommended the state to revisit the state list of OBCs.
Yes.
This was adopted in your meeting dated 17th April 2023.
I think we want to read just we come to page 64.
My lord.
In the middle of the third large paragraph, somewhere in the middle, you'd find the expression accordingly the government of India.
My lord.
You see the reference to Indira Sawhney?
Yes, my lord. That is
After that,
yes, my lord.
you find the expression accordingly the government. Please read that. Accordingly, the government.
Accordingly, the Government of India Ministry of Welfare appointed an expert committee for specifying the criteria for identification of socially advanced persons. Milord, this was the answer. Milord, I was going to praise him. I'm deeply obliged, Milord. Deeply obliged. According to the Government of India Ministry of Welfare appointed an expert committee for specifying the criteria of identification of the socially advanced persons amongst the socially and educationally backward classes, wide Government of India Ministry of Welfare Resolution number so-and-so, adopted on February 1993. The said expert committee submitted its report to the government on 10th March 1993 and subsequently it was laid on the table of both the Houses of Parliament of India. The government had decided to accept the recommendation contained in the said report in compliance of the Supreme Court judgment and expert committee report for applying the relevant and requisite socio-economic criteria for exclusion of the socially advanced persons sections creamy layer from the other backward classes in civil posts and services under the Government of India. The DOPT-OM dated 13th August 1990 was modified wide OM number so-and-so on 8th September 1993 to provide inter alia reservation to 27% of the vacancies of OBC candidates in civil posts.
Criteria. Key criteria. So, social and economic criteria যখন সেট করেছে এটাতে তুমি ডিক্লেয়ার করে নিজের ক্রাইটেরিয়া ভালো করো
From your lordships that what is CRI all about. So, my lord will kindly come to the affidavit in opposition used by the state in this matter, my lord.
Yes.
Lordship will kindly come to page 10 of the affidavit in opposition of the state. My lord, 1160 of 2023. 2013, sorry.
1160 of
2013.
Yes.
Lordship, the affidavit in opposition is used by the state
Yes.
to our, in fact, reply. My lord, there, my lordship will kindly come to page 10.
Yes.
Paragraph, subparagraph F. The commission also takes.
Does not tell. Page
10 minutes.
Abhijit Mukherjee.
My lord,
affirm.
আমি দেখছি আমার না না আমি দেখছি
It's not telling.
This is our you.
না না এইটা তো এইটা ওইটা
Commission's opposition.
combined opposition my lord that state my lord এখন কেন
Oh,
এখন
after the writ petition.
writ petition 1160 writ petition
হ্যাঁ এই যে এটাই your affidavit, state has used any affidavit. This affidavit
that they have used, Millard. That they will come to that.
Look, I need to clarify one thing. To the affidavit of my learned friend's client, that is the Central Commission, where we have used an affidavit. But where I find, Millard, my officer, she was sick. I mean, she met with an accident. That's why she was not in office for some days. Now I feel, Millard, there are some documents which I need to place on record. Why? Lord, the documents which my learned friends are showing, my learned friend is showing, are of 2022, 2023. But my lord, there are documents on record available with us that from 2014 onwards, my lord, we have been sending these, or even before, we have been sending these documents to the National Commission that we have identified XYZ classes as the,
As you did in 2010.
yes,
So you've been repeatedly
sending it to them. Their response is now.
Please include them. They
Yes.
did not include.
They included, but
First time
yes,
in 23.
right.
Is that what you want to say?
Yes.
Fair enough. That we take note of
Yes,
that.
but the only thing is, my lord, if your lordships feel that those documents
No.
are required to be placed on record,
This regard is good enough for us.
very, very, then it's
We
on.
will make note of that submission.
But if requirement, I can hand up copies to your lordship. I have those today.
Please do that if you can.
Yes.
One is enough.
Yes, আর একটা copy দাও।
No, your উত্তর থেকে বলেই যাচ্ছে সেন্টার কিছু করেন গেছে 23-এ প্রথমবার উঠেছে
আরেকটা দাও।
You have filed.
That's all right, Mr.
No,
Trivedi,
but these documents are not on, just take for example, we have one document. আরেকটা দাও।
ওদের স্টেটের কি আলাদা এফিডেভিট দিয়েছে না এটাই?
Yes, we have given this affidavit, but these documents are not on record.
So this affidavit is affirmed by the Joint Commissioner for
Yes, my lord.
Reservation.
I'm relying on that since it had fallen from my lord that what is CRI all about.
Yes,
So they had stated there in paragraph 10.
just my lord, for
give
one.
that. Please give that now. That's good.
Well, for example, please take the pink flag. না, তোকে দিচ্ছি। দেখি রে, আমারটা pink নেই তো। হ্যাঁ, হ্যাঁ।
2014.
Yes, kindly see the letters. এই ওকে একটা সেট দিয়ে দাও।
আমার কাছে আছে তো তিনটে।
সব পাবো। না, এইগুলো আলাদা, এগুলো উনি এখন দিবেন।
Or you take back one.
Yes.
You shall share.
হ্যাঁ। This is April 2014.
Just দেখে নে, তুই দেখে নে। তুই দেখে নে, এখানে 2014 yes.
2014
We will note this, Mr. Dotto, that
Very
you have been consistently
Right.
from, let us say, by 2014. Maybe from 2012 itself. Maybe there's no document right now. I am proceeding on that. We are
Very,
proceeding on that.
very.
If the center chose not to
Yes.
include them, they started their research in 2023. Please carry on, Mr.
It is such a.
My lord,
Hey,
my lord, I am just on that particular affidavit.
The
CRI, my lord. If my lord kindly takes page 10, subparagraph F.
10F here.
My lord, may I read, my lord? The commission also takes assistance of Cultural Research Institute, an expert body under the state government, whenever necessary, to gather detailed information on the applicant class. The commission calls such documentary evidence from the applicant class which may justify the claim to be belonging to any particular class of OBC.
Kindly pause for a moment. We need to put this to rest once and for all. Mr. Dattu, please explain what is the authority status of CRI? Please explain.
Yes, but I'll tell you, Lordship, my lord. My lord, article, as your lordships know, my lord, under the rules of business, my lord, the powers of the governor, my lord, is distributed to various officers and departments of the state, my lord, under the rules of business. One of such is, but if your lordship may kindly take, my lord, my affidavit, affirmed on 11th of March 2024. To my lord, Mr.
Mr. Mukherjee,
Yes.
Abhijit Mukherjee.
Yes.
Yes.
Please take the last two documents at page 38.
Yes.
But this is, my lord, adding to, my lord, the rules of business in exercise of powers conferred by clause 3 of article 166 of the constitution. The governor is pleased hereby to make the following amendments in the West Bengal rules of business as subsequently amended in the first schedule of the said rules under the subheading backward classes welfare department for part 1, part 2 and part 3, the entries relating thereto substitute the following parts and entries, my lord. Your lordships will find, my lord, under serial number Roman 7 in part 1. Matters pertaining to Cultural Research Institute and Commission for backward classes. Now, if your lordships may kindly turn the next page, this page and the next page, at page 40. Sorry. Where this is Miller, the Deputy Secretary, backward classes, writing to the CRI Director. With reference to the above memo, I am directed to say that the Finance Department has clarified that the Central Research Institute has the status of a scientific and technical wing under the department. So it becomes a wing under the backward classes welfare department. And now, my lord, if your lordship may kindly take me page number 41, where this is a note from, my lord, the administrative file, where at the top, my lord, I read, my lord, the administrative department have come up for ascertaining the status of the Cultural Research Institute from the papers in the file and replies submitted by the administrative department on the previous queries. It was found as follows. Please take me the 3. The institute was established in the year 1955 as the scientific and technical wing of the erstwhile Scheduled Caste and Scheduled Tribe Department. Its objective are to conduct studies on tribal life, including their historical traditions, socio-economic and cultural life, attitude, behavior, etc. Now, my lord, this was in 2015. So, therefore, my lord, today, my lord, its status is, as per, my lord, page 40, my lord, a wing or a scientific and technical wing of our BCW department.
The institute was established in 1955.
Yes, it appears to be so. At page 41.
Mr. Dotto, where is this first schedule to the rules, page 38, which you pointed out?
Yes.
Amendment, where are the parent rules?
Parent rules of business, I don't have right now.
What is the first schedule referred to?
But actually, first schedule, Millard, is the distribution of business to various departments and officers.
Is there a document which defines the role, appointments to the CRI, who leads it, who were the persons, how is it functioning? There should be
something. There should be something.
We can get it the next day.
Headed by director, already
Right.
appointing authority of director.
That is at page 41.
Principal secretary, very nice. Other posts, director of CRI, filled up by recruitment rules. So the officials of the CRI are government servants, state
Yes,
government servants.
it appears to be so because 309 means these are all civil posts. Appears to be so, but
the separate DDO,
yes,
drawing and disbursement officer, and heads of account of the separate department.
Right.
Separate from that of the department.
Yes. But
And
finally,
all this is coming up in 2015.
Right.
From 1955, they were functioning how?
But I'll have to take instruction. But off the cuff, Millard, I don't want to make any submission. But that can be Millard brought to the court. Okay.
No.
Director.
Now, my lord, I will not take much of the time, my lord. We've had me another 5 minutes, my lord. I will just to, my lord will kindly take my affidavit, my lord, and then I will deal with their affidavit in opposition recently filed on that day, which will clarify CRIs, and my lord, then I will conclude, my lord, because I have nothing more to say, my lord. My affidavit, my lord, if my lord kindly comes to page 20, my lord. Subparagraph P.
No, what you were showing some paragraph 10 of their affidavit. What?
My lord, I was showing because of CRI, their CRI, and now I will come to their opposition where they have again amplified on CRI, because that was the question which fell from your lordships, that what actually CRI is.
For
And
that you referred to which paragraph?
My lord, paragraph page 10 of
Page 10 of their opposition is
opposition, that initial opposition.
Yes, yes, you showed us, right.
Now, my lord, I am coming to my affidavit there at page 20, my lord. Subparagraph P. Lordships have got it?
Yes.
That the National Commission for Backward Classes observed that one side state government is saying that no specific data on OBC communities under the state list who have been converted to Muslim from any Hindu community is readily available to the state government. On the other side, state government notified converted to Muslims from Hindu communities to the state list of backward classes. However, it is mentioned in the report of the West Bengal Backward Classes Commission that many OBC communities are under the state list of the OBC who have converted to the Muslims from any Hindu community. Now, my lord, once they have converted, my lord, they lose any identity of class. So this is what my humbly submitting, my lord, that once you are converted, the whole purpose of conversion to Islam is that you want to go to a classless society. So you cannot have your cake and eat it too.
They lose their caste.
My lord, there is no caste, my lord. Because Islam is all about classless society. Now, my lord will kindly, I will rush through my affidavit. My lord, now, my lord will kindly come to page 22. Subparagraph F. That the classification of communities as category A, more backward, and category B in the state list of OBC with respect to 143 communities as aforesaid in paragraph 6. I apologize. In paragraph number 6, lordship have got T. I've got it. My lord, I am not used to reading it from the tab, my lord, so I am trying to get accustomed to this particular. Practice makes a man perfect. That the classification of communities as category A and category B in the state list of OBC with respect to 143 communities as aforesaid in paragraph 6, subparagraph 13 were done on the basis of an interim executive summary report, and prior to publication of the final report, final list of OBC was published by the state government. Then we learned, accordingly, the National Commission has recommended to the state government to revisit the state list of OBC. The government of West Bengal has shown lack of initiative on their part to evaluation and identification of posts of equivalent or comparable basis in the aforesaid institutions and have kept the matter pending for over 2 decades for reasons best known to them. The omission or lack of action on the part of the government of West Bengal has led to a situation where a number of bona fide OBC candidates have been compelled to seek judicial interventions due to arbitrary interpretation of provisions of income wealth test under category 6 of the schedule of the office memo dated 8th September 1963 now, 1993. So, my lord, this is what we are trying to impress, and that, my lord, the arbitrariness, my lord, and they are not wanting to evaluate, and they have come to a conclusion which has no basis. Now, my lord, as far as their
about OM dated 8 September 1993. OM dated 8 September 1993, page 66.
Now, my lord, OM dated, which we have referred to now in which I was reading, my lord, OM dated September 8, 1993, has been there appended, my lord, at page 66. Lordship will just make a note, my lord, that my lord will get a exact view, my lord, what actually OM dated said. Page 66, the income. Now, Lordship will kindly allow me to come to their opposition.
Page 66 is determination.
66 of our opposition.
That is determination of creamy layer limit.
Creamy layer, my Lordship. Now, my lord will allow me to come to their opposition to our report, which was filed before your lordships. If my lord kindly comes to page 5, affirmed by Mr. Abhijit Mukherjee. Now, my lord will kindly come to page 5, subparagraph 2. My lord, here they have tried to justify, my lord. In the state of West Bengal, according to the population, Muslim comprise the second highest community in as much as most of the backward communities from the Hindu religion have already been included in the scheduled caste SC list. The Muslim communities are left out for reservation as SC. Therefore, my lord, they are once again trying to prove the rule that they have basically, it's a communal reservation. This analogy which they are trying to say, put before your lordships, is the highest community, in as much as most of the backward communities from the Hindu religion have already been included in scheduled caste list. The Muslim community was left out for reservation in scheduled caste in order to accord welfare facilities to the entire backward population of the state. The state government provides other reservation facilities through other backward classes status as permissible under the law, not only to the members of Muslim community, but also to the members of other religious communities outside the coverage of SC reservation facilities, and as from Hindu, Buddhist, and Jain communities. Now, my lord, I come to the next paragraph 3. Prior to recommendation of class community for inclusion in the state OBC list, open applications are invited by the West Bengal Commission for backward classes to the respondent number 2 herein. Thereafter, hearing are held of the applicants according to the procedure by conducting a proper hearing of the applicant community as well as to the objector or objectors, if any. Extensive field survey by competent technical agencies like the Cultural Research Institute or the Anthropological Department under Calcutta University is conducted, and thereafter the WBCBC recommends for inclusion of such communities in the state list. There is no intention of attempt from the part of either the state government or WBCBC to prioritize any community based on religious affiliation for inclusion in the state OBC list. It is quite unsurprising that having been left out for consideration, the reservation under SC, as stated here, most different backward classes who approach the WBCBC are from Muslim communities. Now, my lord, then again, my lord will kindly come to 4. Inclusion of any class in the state list of OBC from the state of West Bengal is done on the recommendation of WBCBC consideration of relative social, educational, and economic backwardness of the particular class. The state follows a policy of segregation OBC into category A and category B, exclusively on the basis of their social economic backwardness. There is a set of objective criterion deprived from the recommendation of Hon'ble Commission by which the classes belonging to OBC are evaluated in 22-point scales in regard to their relationship backwardness vis-a-vis their prevailing social, educational, and economic standing. Classes securing 15.5 points and above are considered to be more backward, and categories A, while the classes securing 11 or above but less than 15.5 points out at the considered backward category B. Now, my lord, will kindly come to subparagraph 5. The Cultural Research Institute is under the administrative control of the Backward Classes Welfare Department. The CRI is competent agency with technical expertise and know how to conduct survey and field studies regarding the determination of socio-economic status of caste, class, and community as per rules of business of the business BCWD as notified by the state of West Bengal on 28th November 2013. So, my lord, if 2013 CRI came into existence, then what was, how they could come to a list in 2010, 10, 11, 12?
They existed till 1955. But it
My
was
lord, notification,
formalized in
if my lord,
2013.
if my lord kindly comes to R2 page 38, page 38 of this, yes,
affidavit.
yes. They have come, notification is dated 28th November 2013,
No, the next page, Mr. Dev.
38 minutes.
No, come to the next page, 40.
Yes, my lord, 39,
No, no, no. It is from 55, page 41.
my lord.
41, clause 3.
Yes, my lord, 19, yes, my lord.
Given
It-
legal and
My lord,
other
what I,
statuses as by the governor for the first time in 2013.
what I am trying to impress very humbly, my lord, I can give it to, because this is something of national importance and it is the exercise which affects the right of other people. They are going to steal a march over the other communities. Now, even if they have put this CRI into, my lord, just because this is a challenge with regard to 9, 10, 11, 12, my lord. Therefore, I am restricting, if that is taken into consideration, that how could you give it to CRI? Which came, actually got all these, the notification which they are relying upon is of 2013. Then even if CRI was there from 1955, what was its status with regard to making all these field reports and these inquiries in 2009, 10, 11? Now, my lord, in my respectful submission, my lord, so, my lord, we have specifically and categorically stated, my lord, that there are the process which is being followed, my lord, it is not proper, and they could not answer to our queries as and when they were asked for, my lord. And now, my lord, we are just showing those paragraphs, my lord, the judgments which we are relying, my lord, which is already before your lordship. We are relying on 2023-7 SCC 481, my lord. I am just giving the paragraphs, my lord. Sorry. My lord, will only just, my lord, 2023 7. Oh, no, 2023 7 SCC 481.
Tribunal.
My lord, we are relying on this.
Just.
I apologize.
And for assisting in formulation in the commission of different welfare schemes. কোথাও এই কমিশনের গল্প নেই। The board of is confined to rendering specialized assistance, but the full-fledged deliberate is implementation of the scheme, program, etc. Besides, it has been supervised by and under the title Phases of Development. Institute was established as a scientific as well, but when separate head of accounts as identity separate, like subordinate offices under other. Above it is eventually
Correct to that.
very confident.
My lord, two judgments we are relying upon, my lord. Just we will give the citation and the paragraphs, my lord. We will not bother, my lordship. 2023 7 SCC 481 paragraphs which we are relying on are 99, 100, 101, 102, 103. 99, 100.
Yeah, just one.
Lordship.
The PMK judgment.
Lordship. PMK judgment.
Paras
99 to 103. 99 to 103. And my lord.
Yes.
One more, my lord. 2015 volume 4 SCC 697. Ram Singh's case, lordship. 47.
Paragraph.
My lord, from 47 to 52.
All right.
Second amendment. During this.
Now, my lord, one more, I close my argument, my lord, just by pointing out one thing. That, my lord, 102 amendment and 105 amendment. After 102 amendment, consulting the commission with regard to any recommendation is mandatory as per constitution. Whether they have done that or not, my lord, this is to be taken into consideration. No, no, till আমি বলছি এখনো আছে mandatory. My take, my lord,
Very good.
I'm grateful.
We take a 5-minute break. Mr. Doctor, you have said what you have to say. Anything else? to
Yes,
add?
only Milord, the portion of my affidavit, which I require to place in addition to what my learned friend has placed, only that much, and then.
That's it. Very well. Any reply from the petitioners?
Yes, Mr. Chakraborty is,
Where is he?
He's online.
He's online?
Yes.
Give us 5 minutes, Mr. Krishnakumar. We'll come back.
Very well, very well.
একটু লিখে দেবেন একটা কাগজে।
Just একটা পাতা।
জাস্ট একটা পাতা।
CHC
সিএইচ ক্যালকাটা হাইকোর্টই হবে।
small তো?
হ্যাঁ, সব স্মলই হবে।
My lord, I will take 5 minutes. The
আমি
first
একটু
petition.
reply-টা- আমি একটু reply-টা দিয়ে দিই। But I'll take 2 minutes. But I have sending my lord a one pager to your lordship's officers for my lord taking a printout and handing up to the court. But what I find from the Google, my lord, the government of India, my lord, had my lord organized a conference for tribal scheduled caste areas, my lord, at a place called Lohardanga in Bihar, where my lord it was decided by the government of India in 1953 that my lord these central research institutes will be constituted, central tribal institutes will be constituted throughout the country. This is in 1952. Well, based on that, my lord, in 1955, my lord, this was constituted. My lord, initially it was under various departments. Now, my lord, it is under the BCW department. So therefore, my lord, this was, as I could gather, my lord, from Google, that this was set up, my lord, under the aegis of the government of India. This is number one. And number two, my lord, only one paragraph or half a paragraph, my lord, of my reply. গেছে ওটা? এসছে?
গেছে?
হ্যাঁ, এটা এটা এটা। Yes. But whatever I have, my lord, made allegations against them here and there, those are not very important. Please take, my lord, page 9 of my opposition to the Mr. Trivedi's client's affidavit.
Yes, please.
My lord, page number 9, we are towards the middle of that page, we have a sentence starting with even otherwise. Middle of that page.
Yes.
Even otherwise, it is apparent from the allegations and annexures to the affidavit that the state respondent wrote to the NCBC requesting inclusion inter alia in 2018 and 2020, yet it took till February 2023 before NCBC took any decision and left the matter pending for reasons best known to the NCBC. It is stated and submitted that NCBC's actions in the instant case, Rex of ill motive, etc. Not that very important.
So it is not 2014 onward.
No, 2014, but this
2010
18 came because, my lord, my officers were not there. Now, my lord, the documents which
But you are still submitting that from 2014
but
onward.
I am told from 2010.
Yes. That we've noted.
That's all, my lord, I need to submit.
Yes.
I may kindly just have a look to this.
Uh-huh.
This is what, my lord, we got, rather, my lord, my junior got from the Google.
Nilmadhav Kormakar.
Yes.
These are my submissions.
My lord, I am appearing for the petitioner Nilmadhav Kormakar, who is the social worker and he belongs to Kormakar community. And
Could I take your lordship's leave?
due to Mandal Commission implementation, Confederation OBC, SC, ST and minorities is a pioneer organization in Bengal, social and no political affiliated. They are trying their best to implement the Mandal Commission in West Bengal since 1984.
Karmakar is enlisted. First, it was declared in the Jyotibas in the Assembly House, 16.
No, Karmakar, the writ petitioner Karmakar.
Yes, my lord. He's a Karmakar community.
He's Amal Chandra Saha.
No.
No.
Nirmada Karmakar.
Karmakar in another matter in
Appellate side.
appellate side.
What is the number of that?
22145 of 2010. 22145 of 2010. Due to our long struggle, the Central Committee BP Mandal came to West Bengal and toured all over India, and they have identified 177 castes under OBC.
22145 to the
Got the affidavit in that matter. We have filed the state.
Yes.
My lord, I think 176 even list is my 177 castes. They are already identified by the Mandal Commission all over West Bengal. This is the list.
That you have not incorporated here?
No.
Give us this.
কপি কোথায়
দিয়েছি
কাকে দিলেন
আপনাকে দিয়েছি আগে
No.
হ্যাঁ 2010-এ দিয়েছি
থাকলে আরেকটা দিয়ে দাও না
দিয়ে দেবো আপনাকে কোনটা আমি আসছি হ্যাঁ We have filed this matter after the declaration, the administrative order issued by the Principal Secretary of the Backward Class Department on 24th September 2010. Page number 24, my lord. We have challenged this order notification and filed this case on 26 November 2010. This is our first petition regarding the OBC reservation issue. We are the first petitioner. In 1993, the Assembly House declared only 16 community in the Assembly and reservation issued only for 5%. Then 1999, another 2% already uplifted total 7%. Afterwards, on 24 September 2010, 10% reservation issued only for the minority community category and divided between category A, 56 community, and category B, 52. In 52 community, there is a 4 Muslim community also. And as per Mandal Commission recommends 177 castes, but the first reservation we filed the 64 community, only 47 community has been taken from the Central Mandal Commission list. First, the government declared in Bengal only population OBC for 14%. We have raised the complaint to the different department, including the Chief Minister, and we demanded 27% reservation for OBC in West Bengal. At that time, the government of India, Indira Sahani case already implemented 27%, but in Bengal, it's unfortunate. We get the already 7%, and later on 10% only for particular community, total 17%, 10% reservation not yet given. In this matter, already supplementary affidavit already submitted on 4th February 2011. Supplementary affidavit is already in the particular Muslim community. I have already stated this. Only for Muslim with the government, the finance department, minority department, they guideline for the OBC certificate এবং সরকারি চাকরি সংরক্ষণের guideline. They highlighted how they will get the particular community, not the all Hindu community. And they are getting there is a scheme for West Bengal Minority Development Committee and Finance Corporation. They are also getting from the same OBC category. And afterwards, my lord, we have already, as per direction of that Honorable Justice Mr. Patel, we have already synopsis of the case with a copy to my late senior friend on 24th February 2012. We describe how the OBC people are deprived still in West Bengal. The OBC people are deprived. They are not getting the certificate. They are not getting the particular Hindu community. They are deprived. They are deprived from the promotion, and they are depriving the education and institution for admission also. Particularly, my friends issued the Sachar Commission report. In West Bengal, when the 2010, 10% reservation already implemented for the Muslim community. So far, my experience in West Bengal, IS, IPS, WBCS, even judicial service, and so many state government officers appointed due to 10% reservation. So, Sachar Commission, all over it may be right, but in West Bengal, so far, my experience, there is a lot of appointment for they have get due to 10% reservation for last 14 years. In particular,
You mean the Muslim community?
yes, my lord. Yes, my lord.
10%.
Yes, judicial department, IAS, every department.
There must be some pleading in the petition. I've got a
No, that is actually.
that must be
I
some
am
pleading.
drawing my attention to the honorable court. This is the scenario of the at present of a situation. And one particular community mentioned in the category B, Goala Gop. All over West Bengal, their population 1 crore 20 lakhs. They are more 1 crore 20 lakhs in Goala Gop community. Goala community.
Goala Gop.
Goala Gop. Yeah, they have already listed in category B. They are more backward in socially, educationally, and economically. But they have not get the justice. My lord,
They are not included in these.
they are included in the list, but they are keeping the category B. We are the backward class community. We are
What is the strength of this community, you said?
1 crore 20 lakhs. So far, 1931 census report, we have calculated for last 10 years, 2%, 2.5%, 3%, calculated all the things, and already submitting the commission. When the first commission sitting in Calcutta, National Commission came to Calcutta, we have submitted the document evidence
So
on
they
the
are
basis.
given OBC B status.
They are already listed in category B. There is actually discrepancies. They offer proper scrutinize, proper.
What should they get according to you?
No, actually, we are anti category A and B.
Both.
Oh, we want the under one category OBC. Our motto, the Confederation OBC, those who have fight for the social justice, for implementation of the Hon'ble Commission in Bengal, their motto only under OBC. Okay? No A, no B, no C.
Mr. Counsel for the State and OBC and the National Commission, in course of the affidavit, while reading your affidavit and while seeing the affidavits of the state also, we found OBC A, OBC B, and a third OBC category.
No, third
What is this?
No, no.
Yes.
No,
In so far, look at your affidavits with regard to the reservation for the medical seats and other things.
no, that is
You've
for the,
given three categories.
no, because of the constitutional amendment. Want to kindly see?
So there's OBC A, OBC B, and OBC.
No. But 15.4 and but what a kindly see? Reservation 15 for education purpose and 16 is the for reservation for service.
We are concerned with 16.4 only here.
Yeah, we are concerned with the only 16.4.
So,
My lord, there are three, my lord. OBC A, OBC B, and other OBC.
No, other.
What is this other OBC?
What is the meaning?
There in the state list. Is it there? In the state does not have other OBC.
My lord, because we are saying other OBC, we have stated, my lord. in paragraph
No,
10.
only in central state. There is a
But we'll come, we just want a clarification. What is this other OBC? sir?
My lord, आप this-
ठीक है, जो फिर affidavit तो वही, commissioner है।
NRI quota.
Kindly see Article 15, Clause 5,
So we are concerned only with 16(4) here.
16(4) here,
Now,
and nobody has challenged that.
explain, what is this other OBC?
Other-
Other categorization?
My lord, we are just checking. And my lord, one more thing, my lord,
A and B is backward and more backward.
Backward. Only 2 classes.
as far as Bengal is concerned.
Bengal is concerned. In the rest of the country, there is a third category.
My lord, we have, my lord, we are coming. And my lord, one more thing we want.
Petition. Affidavit. नहीं है बोल।
Kindly see the language of Article 15(4).
Yes. Takes assistance.
Yes. Page 16. Total OBC 731, OBC A 457, OBC B, other OBC. এটা আবার কি?
ওবিসিটাকেই তো দুভাগে ভাগ করে
হ্যাঁ, তারপরে other OBC তিন ভাগ হয়েছে।
Yes, Lord, this we have got. If my lord kindly takes up my affidavit, page 72. I mean, not my lord, my client's affidavit, page 72. This was, 16/3/23, letter of the government of West Bengal, Department of Backward Classes. Now, my lord will kindly see the details which have been given by them. Here, my lord, 6.1.61 data relating to admission of MBBS and MD courses in the academic year 2021-22. Then my lord will kindly come to the third point, OBC 731, OBC A 457, OBC B 263, other OBC 11.
What is this, Mr. Mukherjee? Next. This is your document.
And my lord will kindly
Your
come.
client.
My lord, page 73, my lord will kindly come. Explanation the police. Now, my lord will kindly come to page 73.
How about
Page 73, my lord will get the explanation of other OBC. Page 73, my lord.
the person belongs to OBC to get admission through NRI quota, management quota, or private medical.
In private medical college. My lord, this was a discrepancy, my lord, which we had asked them. In our affidavit, we have stated. Now, my lord, NRI may be a creamy layer, my lord. How NRI, my lord? I'm asking a
There are
question to
2
myself.
types of reservation. One in service and another is medical and engineering admission.
education.
Other is called OBC other. That is for medical admission, education,
NRI.
Educational
institution.
Mr. Mukherjee, private medical colleges charge a bomb. The admission for Manipal for against capitation fees is nearly 1 crore.
No, but it is
Think any of this in a Kasai community or any of these communities can afford 1 crore of rupees for a medical admission to the children?
so far private medical colleges.
How can they be treated as other backward?
No,
class?
but some private.
Be treated as SB, special privilege cards.
But so far medical admission is concerned. So far private medical college is concerned, 15% taken up by the total seats in West Bengal by the central government. Then 85%. Then 85% distributed according to the reservations. Then after 85%, according to the rank, they will first got preference in the government medical colleges. Then it will go to the.
Where is the notification towards creation of such other OBC?
No, only OBC A and B for education purpose same and so for services same.
Then what is other OBC?
Other OBC, there is no other OBC. OBC means
Your own document said so.
no, other OBC that means what? That is for admission in a bed.
Why?
Say they are OBC.
They are
But
private medical colleges.
yes,
They charge more than 1 crore. NRI quota, they charge about 1 crore
no,
for medical seats.
medical.
How do you categorize them as other backward communities at all?
No doubt, so far as private medical
The
colleges,
contradiction in terms.
state government has 25% seats. 25% seats in it because the rate will be just like state government. But if somebody gets an admission in medical colleges in Calcutta and somebody gets an admission in Durgapur private medical college, if he gets a state quota, then admission fee will not like the private medical college, say just like there is a committee headed by a retired judge of this one. Their admission should be below, just like a state government. But
Where have you said that in reply to this report which has been filed enclosing your documents?
Commission finds the government of that the government of
Mr. Dotto placed before us that affidavit.
page 72 and 73.
due nomenclature.
No, this report which has been filed by the National Commission.
Yes.
In reply to this, you have used an opposition. What have you said about this other OBC?
My lord, my lord will, our affidavit, page 65, my lord will find that we have objected to this category. Page 65. Of
Other OBC.
Yes, yes, my lord. Page 60, page 65.
The state, you are making money indirectly like this?
No.
Commission
Which
not new nomenclature. Some of NRI quota or
My
management.
lord, 65, my lord has got it. The commission finds that bold portion, my lord, 1.
Other OBC persons belong to NRI.
The other third line, my lord, the other words, other OBC are persons belonging to OBC category took admission through NRI quota of management quota also.
Anyway, we are not concerned with this in the education because we are concerned with jobs.
Only Article 16(4).
Management quota.
I mean, this was amended in 2006.
Other OBC government. What class can
নারায়ণের মধ্যে রিচ বেনিফিট ওদের ওখান থেকে ঢোকাবে এটাকে কিন্তু ক্লিয়ার করছে।
Yes, please carry.
My lord, my last
My lord has
submission
made a note of that, my lord, that we have
since
objected.
1994 to 2010 up to 24 September, 64 caste only identified by the backward class commission. How within 3-4 months the commission identified the category A and B? This is my question. Hurriedly it is done and it is not possible, and they have not maintained any method as identified by the Hon'ble Commission. Last, my lord, I prayed for page 2430. I have challenged this, the notification, category A and category B, and roster. Totally baseless. It should be struck down, my lord.
All right.
Grateful, my lord. This is my last.
My lord, Mr. Kumar may conclude his arguments in respect of 1160, my lord. Sir,
Yes, Mr.
May it please, Lord. I hope I'm audible and visible, my lords.
Yes.
Lords, I propose to
Yes.
I propose to deal with, my lords, the submissions by the state and also with the State Backward Classes Commission broadly in 3 or 4 heads, my lords, under 3 or 4 heads. Issue 1 is on maintainability oblique locus. That's the first point. Second point, my lords, is about the challenge to the validity of the Act. Submissions made by the state on that. The third point, my lords, is really on merits. These are really the broad themes or headings, if I may say so, under which submissions were made by the state and the Backward Classes Commission. Now, first, my lords, on maintainability. On maintainability, reliance was placed on the decision of the Honorable Supreme Court in Chofal's case, Balwant Singh Chofal's case. Very elaborate reference was made to the said decisions. Chapter and verse from the said decision was cited. Just note down the citation for the sake of record, my lords. 2010, 3 SCC 402. First and foremost point that I want to highlight in respect of this judgment and on this point is this. The argument itself has been raised for the first time, I dare say, a decade into the hearing of the case and at the stage of final hearing of the case. This is the first point I want to highlight. This point has not been squarely taken either in the affidavits or the replies or at any stage prior in point of time when this matter has been heard. Having said that, I would also like to clarify, my lords, it's not even remotely my case that it's because they are raising it at a belated stage that it should not be considered. I am saying that even otherwise, it's a completely misplaced submission in my respectful submission. Now, first and foremost, the reason why this delayed argument is something which cannot be countenanced is because of Chofal's judgment itself. Please come to the conclusions in Chofal's case.
You're referring to phase 3.
3 and also the conclusions for lots, page 18, para 181.
Page 2010-3.
3 SCC 402 at 461, my lords.
Yes, please.
Now, at 181, after discussing, my lords, all the various nuances of the PIL jurisdiction and the development of the law over the decades, the court ultimately, please see what it says. 181, paragraphs 1 and 2, my lords can skip for the time being. Please come to 3. Court should prima facie verify the credentials of the petitioner before entertaining a PIL. My lords got 3.
Yes.
Then please see 4. Court should be prima facie satisfied regarding the correctness of the contents of the petition before entertaining a PIL. So the first point to be noted is these are at the prima facie stage, not at the final hearing. These stages have long been crossed in this case. It's been long since these stages were crossed. Then please see 5. Court should be fully satisfied that substantial public interest is involved before entertaining the petition. So all these are threshold considerations. These have all been taken note of by this Honorable Court while entertaining the petition at the first instance. In fact, the matter was heard, my lords were kind enough to observe that on more than one occasion. Matter was heard finally on several occasions on merits. It is here now before this honorable bench because of my lord's tenacious consideration of the matter, my lords. We are really seeing finality of the matter on merits. So I would respectfully submit that it is not open to the state at this stage to come and talk of maintainability. This is the first point on maintainability notes. The second point on maintainability. Please see the rules of the Calcutta High Court. Again, reference was made to the rules for PIL of this Honorable Court. Now, the rules in fact make very interesting reading. First point to be noted in respect of the rules is this. The rules are found incorporated in the appellate side rules. My lords, see that? They are incorporated in the appellate side rules.
Yes, yes.
And they are not incorporated, my lords, in the original side rules. And my lords are really looking at petitions today which seem to be having notation for original side and appellate side. The petitions before my lords. Some are original side writs, some are appellate side writs. Now, please see the rules themselves. Again, I'll for the time being not take note of this distinction. I may not be mistaken for arguing technicality. But please see what the rules themselves say. Please come to Rule 56. Definition of PIL. May I read that, my lord?
Yes.
Public interest litigation shall include a litigation. Please note that. Very important in my respectful submission. Rule 56, my lord.
Yes.
Public interest litigation shall include a litigation, the subject matter of which is a legal wrong or a legal injury caused to a person or to a determinate class of people by reason of violation of any constitutional or legal right, or any burden imposed in contravention of any constitutional or legal provision, or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons is by reason of poverty, helplessness or disability, or socially or economically disadvantaged disposition, unable to approach the court for relief, and for redressal of which any member of the public, not having any personal interest in the subject matter, presents an application for an appropriate direction, order, or writ in this court under Article 226. What is to be noted in the language is this. This is really, my lords, a condensation of the law laid down in several decisions of the Supreme Court on the scope of PILs. That, my lords, will recall. That's one point to be noted. Second point to be noted is, it is as general and inclusive and sweeping as one can imagine. In the plenitude of issues that could be raised.
Yes.
Third point. Please see the non-obstante clause in 56, the subsequent paragraph, after what I read. Notwithstanding anything contained above, in any appropriate case, though the petitioner might have moved the court in the private interest and for redressal of personal grievances, the court, in furtherance of the public interest involved therein, may treat the subject of litigation in the interest of justice as a public interest litigation. Therefore, the scope of the power that is given to the court and the sweeping nature of the power is such that even what may be seen as a private interest matter or a personal grievance matter could still be entertained if it contains a public issue or if it projects a public issue. That's the sweep of the power, my lords, that is given to the court under the rules. That's the third point I wanted to highlight. Fourth point, please come to Rule 57. Modes of entertainment of PIL.
Yes, yes.
Modes, my lords, A, by presenting a petition of motion, complying with the formalities required for filing an ordinary writ application under Group 9, that is residuary, of the classification list being Schedule B hereof, such petition should be placed before the division bench constituted by the Honorable Chief Justice for entertaining public interest litigation. So absolutely no shackles of formality of requirement of specific averments being made in the petition as was sought to be argued on behalf of the state. A PIL petition is filed in the same format as any other writ application as part of residual category. The matter is placed before the Chief Justice, who then places it based on, my lords, the roster before the division bench, which is seized of such matters. Therefore, for the state to argue today that the writ petition does not contain specific averments about ABCD in terms of Rule 56, in my respectful submission, just does not lie. And if I may say so, my lord, the proof of the pudding lies in its eating. This petition was, for all intents and purposes, read, understood, and treated as a PIL from day one. It was placed before a division bench.
Yes.
And heard as such. And one more thing, my lords, I understand in between, the petition was dismissed for default by a single judge because it was wrongly placed before a single judge and restored. And the ground for restoration is that it was wrongly placed before a single judge. My colleagues there, my lords, locally placed there, will circulate that order also. In fact, it appears, my lords, petitioner number 2 had expired, and that's also placed on record. Yes. And there are two specific orders also which I want to highlight. Please, my lords, can just make a note of the dates of the order. I will not really trouble my lords on that. One is an order of 12th of August 2011. The other is an order of 8th of July 2011.
No.
That what has been handed up to my lords is perhaps the order by which the restoration took place.
Restoration.
Apart from that,
what are the dates of the order you are referring to?
One is 8th of July 2011, my lord.
And the other?
12th of August 2011.
Okay. Yes.
Now, in fact, on 8th of July, the court, my lords, division bench of this honorable court, consisting of Justice J.N. Patel, who was then the Chief Justice, my lords, and Justice Ashim Kumar Roy. This is right at the beginning, my lords. Now, please see what the order is. We have heard the learned counsel for the petitioner as well as the learned advocate general for the respondents. Prima facie, we are of the view that the respondent West Bengal Commission for Backward Classes can consider re-examination of their decision, which is the subject matter of challenge in this petition, particularly after considering the materials placed before this court in the affidavit in reply by the petitioner. Learned AG submits that he will seek necessary instructions in the matter and make a statement on the next day. We make it clear that as we have started hearing the matter In case the commission decides to reconsider the subject matter of the petition, petition can be disposed of by passing an appropriate order. Let the matter appear on 12th August for further hearing. All parties are concerned, etc. Now, on 12th of August, please see what the court ordered. Learned Advocate General. My lords, have that order of 12th August, my lord. Yes. Learned Advocate General has placed before us abstract of the resolution. My lord, Justice Tapabrata Chakraborty has that, my lord. 12th of August.
I'll share.
Oh, I'm so sorry, my lord.
Yes.
Learned Advocate General has placed before us abstract of the resolution of the West Bengal Commission for Backward Classes in the matter of re-examination of the decision, and it says that the question of re-examination of the cases was not considered to be prudent in view of the reasons: A, no addition in respect of any communities to the contrary has been received. Revision of the commission in respect of 42 communities during the period 5/3/2010 to 24/9/2010 appear to have been made under the West Bengal Commission for Backward Classes Act as embodied under 9, which with amendment by the West Bengal Commission for Backward Classes Amendment Act of 2010, same is taken on record. Matter is adjourned to 26 for further hearing on merits. Now, these two orders I'm highlighting because right from the beginning, there was no doubt that this is a PIL and the matter was being considered and the court was engaged in consideration of the matter on merits. One more thing, my lord. My lords would have noticed that this order is passed in WP 60.
Yes.
Now, WP 60 was filed at a time, my lords will recall, when the executive orders were passed, notifying 42 communities. Now, this was followed by, my lords, the Act of 2012, where this list of communities which were added in 2010 were verbatim lifted and placed in the schedule to the Act. 1160 was filed, challenging, my lords, that Act and that inclusion. Therefore, the entirety of these PILs, be it WP 60 or 578 or 1160, they are all one connected to the other. All the matters, my lords, were treated together as public interest petitions always without any doubt about their maintainability. This is the important point I wanted to highlight for my lord's consideration.
Your Kormokar's matter was also appeal, or it was a your matter? It was a public interest litigation.
Yes, ma'am. Several times heard, but no stay order obtained from the court.
Therefore, it is too late in the day, my lords, both literally and figuratively, for the state to raise hyper-technical objections, saying that there is no averment, necessary averment in terms of the rules, or that petitioners have not mentioned how they are aggrieved or how they are filing it in public interest, etc. Moving on, my lords, two more points on maintainability. It is sought to be argued that PIL is entertained only where some specific, my lords, violation of fundamental right, or for that matter,
এই কার্ডটি কোথায় গো? এই কার্ড। কোনো তারিখ আছে কিছু আছে? এখন Come back on the next day, Mr. Goswami. One of us won't be there in the, this bench cannot sit from 1st April to 15th April because one of
Oh, I
us.
see. Oh, I see. Can I request for, can I request for day after if it's not inconvenient for my lords, day after, if it's not inconvenient for the court?
Be possible, Mr. Kumar. That is why we wanted to finish it off so that we can reserve the matter.
I know, my lords. I thought because my lords have been kind enough to give us a lot of time, my lords, and we have almost reached the fag end, my lord.
To finish it on, we are keeping it on 17th of April at 2 p.m. This bench will sit. You finish it off so that we can.
Oh, I see. I was only going to request. I'm so sorry, my lords, to be even persisting. I quite see the pressure of work, my lords, on the court. I quite see that both my lords have your own determination. Can it be either Thursday or Friday, my lords?
Won't be possible because this is not a regular wage. My lord has matters in his.
I know, my lords. My lords have your own determinations. I understand. I quite see that, my lords. We are really at the fag end, my lords.
Okay. তোমার কি বলছি?
One is Sanjeev.
Mr. Kumar, we are keeping it on 17. Can you hand over to us a note on your arguments by this time?
I can, but I can do that. In fact, I was going to.
Only in reply.
That's correct.
We don't want to have a Pandora's box.
I understand, my lord. My lords are having your hands full. I quite understand that. I was going to suggest this, my lords, if that finds favor with the court. In fact, I want to take only about 40.
You kindly give us a note in through to our officer concerned. We will get the note. 17th, we shall formally hear you and reserve the judgment.
I understand, my lords. I'll do that. I was only requesting because it's only 45 minutes that I want to take maximum because I'll give the note also. If it can be either Thursday or Friday, my lords, I'll be grateful.
This won't be possible, Mr.
Oh, I see. Oh, I see. I'm in my lord's hands, my lords. I'm in my lord's hands. Whatever my lords consider appropriate.
We really expected all parties to conclude today.
Because, in fact, last couple of hearings, my lords, I had perhaps my lords may have noticed, I had logged in fully, my lords, so that I thought if my turn comes, I'll complete it. Only about 45 minutes for me, my lords. Only about 45 minutes.
As far as the queries which had fallen from your lordship, we have got, my lord. So, my lord, on the 17th, my lord, we'll furnish those documents, my lord.
Each document.
My lord, it had fallen from your lordships that from 2014, the recommendations which were made by the state with regard to inclusion of OBCs, whether that has been done or not. We have
put in a note also.
Well, that is
yes. Make sure you do this, Mr. Trivedi.
Lordship.
That how many classes as included by the state have you included? Name those classes.
Not even one after 2014.
After 2004.
2014, not even one.
Before that, how many have you?
My lord, therefore, my lord, we have also got a breather, my lord. We will come with comprehensive detail by way of a notes of submission.
Please exchange.
Please exchange the notes of submission.
My lord, yes, my lord, we have, since my lord has given us ample time, my lord. We are today on the.
So we wouldn't have given to you ample time. Because of
Mr. Krishna Kumar has bought time for all of you. I mean, we were really keen on concluding it today. But after today, neither his my senior brother nor I can spare it to them.
Mr. Trivedi, learned advocate appearing for the National Commission, has concluded his arguments. Concluded his arguments. So, let's see, matter.
The learned advocate general has made some additional reply. Mr. Learned counsel for petitioner in WP 22145.
Kartik Chandra Kapas. Kartik Chandra Kapas.
Mr. Kapas
has concluded submissions. Mr. Guru Krishna Kumar has commenced his reply, but could not conclude the same. Mr. One of us is on circuit in the immediate future. The bench is not available until 16th of April 2020. Some matter for conclusion of arguments and for the NCBC to furnish information as required on 17th April 2020. AG has made additional submissions and has also furnished certain documents with regard to the constitution of the CRI.
Let the same be kept on record.
Lords, I'm sorry, my lords, one procedural thing, my lords. 17th, I just noted from our Supreme Court calendar that it's Ram Navami and a holiday. I hope it's not a local holiday for the High Court, my lord.
It's not a holiday. You can come.
Very well, then it's fine, my lord.
No, 17th, there is no holiday.
Then it's fine, my lord.
You can come over.
Then it's fine. Very well, my lords. Then in fact, it suits me, my lords, because we are free here in Supreme Court, so I can go through it fully, my lords. I am obliged, deeply obliged.